Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Good afternoon to everybody watching our stream over on Facebook Live. I am Regina and I am your host for the Best Bar Ops lecture series titled Frequently Asked Topics on the 8 bar subjects. Welcome to our dear speaker, deans, professors, and bar takers tuning into our stream. Last week we had a good run of various lectures that answer your FAQs on different bar subjects, which you may always watch again here on our Facebook page. We'd like to thank all of our previous speakers for sharing with us everything they know in order to help our dearest bar takers. The Frequently Asked Topics in the 8 Bar Subjects lecture series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Edu. Thank you so much, Rex Bookstore and Edu Campion, for collaborating with us on this event. Today's program aims to determine the most frequently asked questions in the 8 bar exam subjects and the ways to answer them, namely for criminal law and special penal laws. These FAQs will be determined and answered by a distinguished guest this afternoon. He has prepared presentations to help the bar takers as they take the exam of their life. To introduce this afternoon's speaker, Dean Gemy Lito Festin finished his bachelor's degree in psychology at the University of Santo Tomas, where he also earned units in Master in Psychology. Later, he earned his degree in Bachelor of Laws at San Sebastian College Recoletos, where he also finished his Master of Laws in 2014 and was conferred Benemeritus, an honor equivalent to magna cum laude. Dean Jim has been a practicing lawyer since 1995, became a senior partner at Fojas, Salinas, Tan, and Festin law offices from 2000 to 2007, and is currently senior partner at Padilla, Villanueva, Festin, and Garcia law offices. He was a former supervising lawyer at Sebastian Office of the Legal Aid and rendered government services as Public Attorney 2 in Manila's District Office of the Public Attorney's Office, Department of Justice for 4 years, and later as Legal Officer 4 in Manila City Council, City Hall of Manila for 6 years. Despite his busy schedule, Dean Jim still manages to contribute notable efforts to the academe. He is currently the Dean of Polytechnic University of the Philippines College of Law and the Bar Review Director of the PUP Bar Review Center. He is a professor of criminal law in PUP, University of Makati, and Manila Adventist College School of Law, is a bar review lecturer and a mandatory continuing legal education lecturer, and he is also the holder of Chief Justice Manganiban Professorial Chair on Liberty and Prosperity. Aside from his active efforts in teaching, he has also authored and co-authored several books used by bar takers and lawyers alike. He pioneered the Law Faculty Association at San Sebastian College Recoletos College of Law in 2009, where he used to teach, was the commissioner of the Committee on Bar Discipline of the Integrated Bar of the Philippines, and is also the former president of the Integrated Bar of the Philippines Manila 1 chapter. He is a legal consultant of Kabalikat ng Bayan sa Kaunlaran Foundation, Inc., a non-stock, non-profit socio-economic civic organization that aims to uplift the underprivileged residents of Manila, and also sits as the president of the Philippine Association of Law Schools. Without further ado, let's all welcome this afternoon's lecturer, Dean Gemy Lito Festin.
Okay, thank you, Reggie. Thank you, Rex Educampion, for partnering with the Philippine Association of Law Schools in this project. And a pleasant good afternoon to everyone. I hope you're all safe and healthy, and keep safe and healthy. No, this is it. This is the last step in becoming a lawyer. So go and fight for your dream, the dream that God planted in your hearts. No, and stay close to God, because He's the one who gave that dream into your hearts, and fight for it. Fight for the dream. He will give you all the resources that you need. So bear with me in this whole afternoon. We will have a journey in criminal law. We will discuss on Book 1, Book 2, Special Penal Laws, and the indeterminate sentence law, and some bar questions related to criminal law, as well as other things, no? Other things that you need to remember. Okay, so let's go to Book 1. Let's go first to, we will discuss based on syllabus, the revised syllabus now, given by the Supreme Court. So let's go to Book 1, Concepts and Principles in Criminal Law. What is criminal law? It is defined as the branch of public law, it's a branch of public law which defines a crime, treats of its nature, and provides for its punishment. It defines a crime, treats of its nature, and provide for its punishment. So why do we have to know the definition of a criminal law? Because if it is a criminal law, in case there is a doubt in the interpretation or construction of a penal law, then it is entitled to what? An interpretation in favor of the accused and strictly against the government. So the syllabus, nakita natin, sabi ng it will discuss on mens rea and actus rea. So permit me to use the whiteboard. So mens rea and actus rea. So this is applicable to felony, no, to intentional felony or dolo. Mens rea means criminal mind. Actus rea means criminal act. Okay, for one to be liable criminally for intentional felony, no, these two must concur. The person must have a criminal mind as well as a criminal act. So if he does not have, if he only have a criminal mind but no criminal act, then he is not criminally liable. When is this possible? No, intentional, no, diba? Internal acts. I'm sorry. Internal acts are not punishable. You can think of any crime, heinous crime, but for as long as it stays in your mind, there is no overt act, then there is no criminal liability. So, because internal acts are not punishable, no, unless there's a person will be liable if there's already an overt act. Now, could there be no criminal mind, but there is a criminal act? Yes, in exempting circumstances, no, where there is no criminal act, but there is civil liability, like absence of intelligence. For example, a 10-year-old boy who stabbed and killed his classmate is also a 10-year-old boy. No? Is there a criminal act? Yes, because his classmate died. Is there a criminal mind? No, because of the absence of intelligence. No, there is no criminal mind, but there's only criminal act. So For a person to be criminally liable, these two must concur, mens rea as well as actus rea. Okay, let me proceed. Now, well, there's a felony, crimes, acts, or omission punishable by the RPC is deemed as a felony. So if the criminal act is not punished by the revised penal code, it is not a felony. Give the sources of criminal law. Sources are the following: the revised penal code, the acts of the Philippine legislature, the National Assembly, the Congress of the Philippines, of course, yung Batasang Pambansa, and other laws like presidential decrees and executive orders. It's like issued by then President Marcos. The Spanish Penal Code of 1870, where we copied our revised penal code. Question: are there common crimes, common law crimes in the Philippines? So there is no common law crime in the Philippines because under Article 21 of the revised penal code, it expressly provides that no felony shall be punishable by any penalty not prescribed by law prior to its commission. Or the rule is nullum crimen nulla poena sine lege. Nullum crimen nulla poena sine lege. There is no crime if there is no law punishing the same. There is no crime if there is no law punishing it. So this nullum crimen nulla poena sine lege was the subject of the bar exams in the past. So many times it was asked, no? Crime is the product of the law. Okay. Other principle. What about the doctrine of pro reo? The doctrine of pro reo. Baka lang itanong sa bar. The doctrine of pro reo, no? When these circumstances are susceptible of two interpretations, one favorable to the accused and one not favorable to the accused, then it should be in a way lenient or liberal to the offender. Okay? Liberal construction in consonance or consistent with the constitutional guarantee of presumption of innocence. Okay? So how is this applied? No? Following the pro-doctrine principle under Article 48, if you can recall, it's the complex crimes. No? Crimes are complex and punished with a single penalty. The rationale is that the accused who commits two crimes with single criminal impulse demonstrates lesser perversity than when the crimes are committed by different acts and with several criminal resolutions. So that is how it was applied. Now, another basic principle, common bar problem. Okay, enumerate the constitutional limitation on the power of Congress to enact penal laws. We know this already: ex post facto law, due process, equal protection of laws, bill of attainder. So, okay, let's discuss an ex post facto law. What is an ex post facto law? Okay, number one, it is one which makes an action done before the passage of the law and which was innocent when done criminal. No, it makes an action done criminal before the passage of the law and which was innocent when done, and punishes such action. Second, one which aggravates a crime or makes it graver than when it was committed. No? So, pinabigat yung act at that at the time that it was committed. Third, is one which changes the punishment and inflicts greater punishment than the law applicable to the crime when it was committed. Fourth, one which alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of the offense in order to convict the defendant. So it receives less or different testimony. No? Fifthly, one which assumes to regulate civil rights and remedies only, pero it in effect imposes a penalty or deprivation of a right, which when done was lawful. And lastly, one which deprives a person accused of a crime of some lawful protection to which he is entitled, such as the protection of a former conviction or acquittal or a proclamation of amnesty. But note, however, no, if the statute is penal in nature but favorable to the accused or convict, and the accused or convict is not a habitual delinquent, you know that the penal statute will operate retroactively without becoming an ex post facto law. What about a bill of attainder? No? Congress cannot enact a bill of attainder. So what is a bill of attainder? A bill of attainder is a legislative act which inflicts punishment without judicial trial. What other constitutional limitations? Yung, well, we know this already, equal protection of laws, no? Due process clause, no? The right to be heard under Section 1 of Article 3 of the Constitution, no person shall be deprived of life, liberty, or security without due process of the law, nor shall any person be denied the equal protection of the laws. So let's go to theories of criminal law. Theories of criminal law, we have the classical, and we have the, of course, there are still others, but this is the common one, positivist. Yeah. This was asked several times in the bar examinations, and it probably will be asked also, no? But you know this already, because the basis of criminal liability in classical is that a person has a free will, no? Free will to choose between evil and good. So therefore, the purpose of the penalty is retribution. In classical, the purpose is retribution. Insofar as positivist, no? A basis of liability, man is subdued by a strange and morbid phenomenon which compels him or conditions him to do wrong contrary to his own volition, no? Which conditions him to do wrong contrary to his volition, and the purpose of penalty is not retribution. The purpose in positivist is the prevention or correction. Now, meron ding isa na tinatawag na eclectic. Eclectic or the mixed theory. We have the eclectic or the mixed one. It is the combination of both, no? Combination of positivist and classical thinking. Crimes that are economic and social in nature, no, should be dealt with in a positive manner. We also have another one, which may be what we call as the utilitarian. Ito naman is the state should be protected from from actual or potential wrongdoer. It's an extreme. It should be, the state should be protected from an actual or from that of potential wrongdoer. So to what theory do we subscribe? We subscribe to that of, classical, but there are certain provisions that we apply the positivist theory, just like the exempting circumstances as well as the justifying circumstances. Okay. Let's go to other point. Characteristics of criminal law. Characteristics or features of criminal law. General or generality principle, or we have the territorial or the territorial principle, and we have also the prospective or retrospectivity. Okay. Do not interchange the concept of the generality principle from that of the territoriality principle. Most students memorize this, but sometimes instead of the generality, they mistook it as the concept of territoriality rule. So not to be confused, you start first with all persons, because generality refers to persons. So all persons living or sojourning in the Philippines are subject to our criminal jurisdiction. Kasi when you talk about territorial, it refers to a place. No? Sa generality, persons. So we start by saying all persons living or sojourning in the Philippines are subject to our penal law. So a person cannot just claim, or so in my country, possession of marijuana or shabu is perfectly allowed. So since I'm a citizen of the state and I'm not a Filipino, I am not criminally liable. Is that argument tenable? No, because of the generality principle. So all persons, whether you are living here or you are just a tourist here, you are sojourning in the Philippines, are subject to our penal law. Is this an absolute rule? No. There are two exceptions. Exceptions are the following: if it is covered under a treaty or laws of what we call as preferential application. Agreement between another country. In the visiting forces agreement, a crime committed by an U.S. military personnel, now as against a fellow U.S. military personnel, and the crime is committed within the Philippines, we do not have jurisdiction to try the case because of the visiting forces agreement. No, it will be the U.S. who will have jurisdiction to try the case. But this is not applicable when the crime is committed by a U.S. military personnel as against a Filipino citizen. We do have jurisdiction to try the case. Laws of preferential application. It gives preference to a particular class of persons, so such that if you belong to this particular class of person, then you are not criminally liable. No? Halimbawa, si President Biden, of the United States who visited the Philippines, no? Who, for example, he drives his car in Ross Boulevard and he bumps on a pedestrian, would he be criminally liable? No, because of this. So who are not or exempted? The sovereigns or the heads of the state, ambassadors, ministers, plenipotentiary, ministers, residents, and charge d'affaires. They do not have criminal liability if they commit a crime within our territory, within the Philippines. Okay, let's go to territorial principle. We can explain the general rule dito sa territorial principle in two ways. So all crimes committed, the first one, all crimes committed within the Philippine territory, then we have jurisdiction to try the case. Philippine courts has jurisdiction to try the case. If the crime is all crimes committed outside the Philippine territory, then no jurisdiction. So this in essence is the general rule. So you won't be confused. Ito na lang, no? Tatandaan nyo. So lahat ng krimen ginawa sa Pilipinas, we do have jurisdiction to try the case. If the crimes are committed outside the Philippines, sa labas ng Pilipinas, wala tayong pakialam. We do not have jurisdiction to try the case. The question is this an absolute rule? No, it's not an absolute rule. Under the second one, no? The rule is all crimes committed outside the Philippine territory, we do not have jurisdiction to try the case. However, this is not an absolute rule, where there are cases where although the crime was committed outside the Philippine territory, yet Philippine courts have jurisdiction to try the case. And what are those? Those which are enumerated under Article 2 of the Revised Penal Code. Okay. Clear natin yan. Okay. Exceptions. There are a lot of bar questions under the first exception. Should or commit an offense while on a Philippine ship or airship? Okay, let's illustrate this. Assuming that this country is Vietnam, and this is the Philippines. Of course, we do not recognize the 9 dash rule. So this is our territory. So in between, if the vessel is here, do we have jurisdiction to try the case? No? It depends if it is a Philippine ship or airship. And when you know that it is a Philippine ship or airship, if it is registered in the Philippines. If this vessel is not registered in the Philippines, we do not have jurisdiction to try the case. Okay. Now, if the vessel is in the Philippines, do we have to determine whether it is registered in the Philippines or not? No, because in this case, we follow the general rule. Because the crime is committed doon sa Philippine territory natin, we don't have to determine whether it is registered or not. Okay? Sir, if the vessel is in Vietnam and the crime is committed inside that vessel, do we have to determine whether it's registered or not? No, we don't have to determine because the crime is within the territory of another country. No, that country has jurisdiction to try a crime committed within their territory. So this one is only applicable when the vessel is what? It is in the high seas. And secondly, registered in the Philippines. These two must concur. Tandaan niya, baka lumabas sa bar yan. The vessel should be in the high seas and registered in the Philippines. If it is registered in the Philippines, okay, but if it is within our Philippine territory or in Vietnam, we don't have to determine, no? Because this is only applicable when the crime is committed outside the Philippines that you need to register and it is in the high seas. Pag nasa high seas yan, dapat registered in the Philippines or outside the Philippine territory. If it's outside the Philippine territory, two things that you need to know. First, it should be in the high seas. Second, it is registered in the Philippines. If it is within the territory of another country, we don't have jurisdiction. If it is within the Philippines, we apply the general rule of the territoriality rule. Okay? Now, misleading question. So if you analyze the bar, this vessel is owned by a Singaporean. Okay? Is that material? No, it's not material. It's not the ownership of the vessel which is important, but no, where the vessel is registered. Another, the crew are all Indonesians. Do we have jurisdiction to try the case? Yes, if it is in the high seas and if it is registered in the vessel. So the citizenship of the crew is a material. The citizenship likewise of the owner of the vessel is immaterial. Okay? So remember that. This may be asked in the bar. Second, should forge or counterfeit? What should be forged or what should be counterfeited? Any coin or currency notes or obligations and securities issued by the Philippine government. So, let's go back to our illustration. Assuming A is a Vietnamese who forged and counterfeited, no, yung 100 peso bill natin, o kaya yung coins natin. If it comes to the Philippines, can A be prosecuted? Yes. Because of paragraph 2 of the territoriality rule. That even if the crime is committed outside the country, but if the act consists of forging or counterfeiting coin or currency notes or obligations and securities issued by the Philippine government, we do have jurisdiction to try the case. Treasury bill is an obligation. Philippine charity sweepstakes, Philippine sweepstakes is also an obligation issued by the Philippines. Third, should be liable for the nakalagay doon, introduction of the obligations and securities mentioned in the preceding article. So this is only limited to obligations and securities. It did not mention, the law did not mention coin or currency notes. So this refers to the act of a smuggler, introducing daw a smuggler. Let's go back to the facts. Bawa, si B. B is a Vietnamese, no? and he had a partner, Filipino counterpart. No, they met on the high seas. No, he smuggled the forged obligations and securities issued or by forged by A. Nag-forge si A ng obligations and securities and he gave it to B. B is about to give it to C. And they met on the high seas, not in Philippine waters. Do we have jurisdiction to try the case? Yes. Yes. Next. Number 4. Should commit a crime against national security and the law of nations. Memorize the crimes against national security or the law of nations. Why? Halimbawa, rebellion is committed outside the Philippine territory. Halimbawa, si F is supporting rebellion in the Philippines, purchasing arms to support, and he's the leader of rebellion in the Philippines. Can he be prosecuted in the Philippines? No, he is not. He cannot, because the crime is not against national security, because rebellion is a crime against public order and not against national security. So what are the crimes against national security? Treason is one, espionage is one, law of nations, piracy, mutiny are also included. Okay, that's number 5. Number 4 is if he's a public officer and he commits a crime in relation to his function or his duties. So ergo, not all crimes committed by a public officer abroad will be prosecuted, can be prosecuted in the Philippines. No. The crime committed by a public officer must have a relation to his office or function or duty. Kung pinabili lang siya ng kanyang boss and then he misappropriated the money of personal money of his boss, then is that he cannot be prosecuted in the Philippines. It will be different if he's a disbursing officer in abroad sa Philippine embassy. And he committed the crime of malversation or even bribery. Then he would be liable. He would fall under this one, although the act is committed outside the Philippine territory. Now remember that. So we have prospectivity. This is the third characteristic. The prospectivity principle. Ang prospectivity principle, do not forget that penal laws do not have a retroactive application. The law looks forward and not backward. Lex prospicit non respicit. Lex prospicit non respicit. The law looks forward and not backward. Exception to the general rule, of course, if the penal law is favorable to the accused, who is not a habitual delinquent. If it's favorable to the accused, then it can be given a retroactive effect, except when the accused is a habitual delinquent, or if the law expressly provides that it should not be given a retroactive application. Let's go to the repeal of penal laws. Repeal of the penal laws. It also affects the principle of prospectivity. Now, let's go to repeal. So there's a first law. Two instances. So there is a the first law or prior law and a second law. The second law expressly, no, repealed the first law. What is the consequence? You also have a situation where there is a first law which was repealed impliedly repealed the first law. What is the implication? Okay. If a penal law is expressly repealed by another law, yung ano, ito sinabi natin, the first illustration, expressly repealed by another law, the crime is obliterated. What are the consequences? So number one, yung mga pending criminal actions will be dismissed. Pending actions will be dismissed, and one already convicted under the repealed law and serving sentence by virtue of a final judgment shall be released. No, they shall be released unless he is a habitual delinquent or if the law provides otherwise. The reason, because there is no more law punishing the same. What about when it is impliedly repealed? No? If a penal law is impliedly repealed, we call it repeal by reenactment. And the act punished in the first law is still punished in the second law. No? The following are its consequences. Number one, yung mga pending case is not dismissed. Second, the penalty in the second law will only apply if favorable to the accused who is not deemed to be habitual delinquent. Now, iba yon if we're talking about when the crime is expires. We're talking about, in this case, the crime is repealed. No? But if the penal law expires on a fixed date, nakalagay doon sa batas, it has an expiration, no more conviction can be had subsequently. But an offender already convicted and serving sentence by final judgment under the penal law before its expiry will not be released. The benefits are not retroactive. Okay. Halimbawa naman, sir, when the law which expressly repeals a prior law is itself repealed, no? What will happen? What will be the consequence? Bawa ito, merong third law. Ni-repeal yung second law which expressly repealed the prior law. Sa second illustration, meron ding third law which also repealed the second law. If there is a law with that repealed a law that expressly referred the first law, ang tanong, kung ito ba mare-revive? Will the first law be revived? In the second illustration, will the first law or the prior law be revived in this case? No? When the law, sa first illustration, when the law which expressly repeal a prior law is itself repealed. Ito yung third law. The first law, will it be revived? The law first repealed will not be revived. No, unless the repealing law so expressly provides. No? But the general rule is that the first law will not be revived. The first law repealed will not be revived. Second illustration, when the law which impliedly repeals a prior law is itself repealed, the prior law is revived. So that's the difference between the two. Yung isa, revived unless the repealing law or the third law provides otherwise. This is revived. This is not revived unless the law provides otherwise. Okay? Let's go to another point. Okay, we say that penal laws, how will it be construed? Penal laws in favor of the liberal, penal laws must be construed and interpreted liberally in favor of the accused. But remember, itong interpretation is only applicable if the law is ambiguous and leaves room for interpretation and accused is not a habitual delinquent. Now, meron din tinatawag ng equipoised rule. What is this equipoised rule? Where the evidence for the prosecution and the defense are equally balanced, the scale should be tilted in favor of the accused in obedience to the constitutional presumption of innocence. Almost pareho sila ng the same as that of pro reo. But remember, equipoised rule, you start first with the evidence, no? When the evidence for the prosecution and the defense are equally balanced. Now, it should be tilted, the scale of justice should be tilted in favor of the accused, again, in consonance with the constitutional provision of presumption of innocence. Okay, let's continue. Cases, alimbawa naman, foreign vessel in the Philippines. Cases where the offense is committed on board a foreign vessel while in the Philippine waters. No? Number one, do we have jurisdiction to try the case? Number one, situation. Kung warship yan, walang problema. If the foreign vessel is a warship, then our country have no jurisdiction because the ship is deemed as an extension of the foreign country to which it belongs, and it's not subject to the laws of another state. And this is where we have the English rule and the French rule. No, if the foreign vessel is a merchant vessel, no, there are two rules as to jurisdiction. Do not apply English rule and French rule if it is a warship. A warship is an extension of its country or the country that it or the flag that it carries. Foreign merchant vessel. So we have the English rule and the French rule. Now, how do we differentiate these two? Crimes on board a vessel while on waters of another country are triable in that country. So that's the English rule. So crimes committed on board a foreign vessel while on waters of another country are triable in that country or in that host country, unless it only involves purely internal management of the vessel. If it is sa French rule naman, such crimes are not triable in that country, no, unless those affect the peace and security of that country or the safety of the state is endangered. Pero they will arrive naman at the same conclusion. No? Halimbawa, this is the Philippines. Okay? And again, siguro Vietnam ulit. The vessel is from Vietnam and the port of the destination is the Philippines. Bawa sa Manila. Okay? That's the first illustration. The second one is it will only pass through the Philippines. Bawa, yun. Going to perhaps Australia. So, dumaan siya sa Pilipinas, no? So, here it's the first one is in transit. The first one is we are the port of destination. The second one is it's in transit. So, what is the implication in this case? If the Philippines is the port of destination of the foreign vessel, no, and it is not in transit, just like in the first illustration, no, any crime on board the vessel, kahit possession ng opium, no, as held in the case of Asing, no, it is triable in our courts, irrespective of whether the crime involves public order or not, no, unless the crime committed involves internal management of the ship. This is the application of the English rule. So if the Philippines is the port of destination, lahat ng kahit na possession lang yan, no, of opium, we have jurisdiction to try the case, no? Unless the crime involves purely internal management. Now, in the second illustration, while the real port of destination is Australia, and it was only in transit in the Philippines, in transit through the Philippine waters, the crime is triable only if it affects the breach of public order, no? If not, it is not triable in our country. Hence, halimbawa, yung possession ng opium, with Philippine courts have no jurisdiction if it is only in transit in Philippine waters and the port of destination is Australia. No? So if it is mere possession, unlike the first illustration where we have jurisdiction, the second illustration, mere possession of opium is not punishable in the Philippines unless the opium is landed. So meron ng breach of public order. Okay? Or unless when the case involves smoking an opium in our territory. Because why? It already constitutes a breach of public order as it causes such drug to produce its pernicious effects in our country. Okay? But whatever it is, we will arrive at the same conclusion. A continuing crime, halimbawa, committed on board a foreign vessel sailing from a foreign court and which enters the Philippine territory. Nagsimula sa Vietnam, halimbawa. Tapos, it enters the Philippine territory. It is triable before Philippine courts. No? If the act is not punishable in the foreign country, the vessel originates, but it is punishable under our laws, our courts have jurisdiction to try the case. Okay. Yon. Crimes committed on board a foreign, let me just remind you, crimes committed on board a foreign merchant vessel while on the high seas are not triable in the Philippines. Philippines have no jurisdiction to take cognizance of crimes committed on high seas on board of a transport or other vessel not registered or licensed in the Philippines. This is not included, but kasi dapat basic to felony. When we talk about felony, acts or omissions punishable under the revised penal code are deemed as felony. So we have dolo or culpa. You have freedom. You have intelligence. And you have third, criminal intent. Intent, or you have malice, evil motive, evil intent. In culpa, you have freedom, intelligence, you have imprudence, negligence, lack of foresight, and lack of skill. So, is good faith a proper defense in dolo? Yes. No. Good faith negates criminal intent. If a person acts in good faith, no, it destroys criminal intent. So there is no criminal liability. Question: is good faith a defense in culpa? No. No. A person may be acting in good faith, but he can be also at the same time acting with negligence. So what is the proper defense insofar as culpa is concerned? No? If one is charged with imprudence, negligence, lack of foresight, and lack of skill, good faith is the defense, but exercise of what? Due diligence. Or he exercised the same with caution. No? I'm not overspeeding. I'm within the speed limit allowed by law, and the pedestrian all of a sudden just cross the street. Now, these are the elements of also voluntariness. Okay. Just a reminder on that. Actus non facit reum nisi mens sit rea, a crime is not committed if the mind of a person performing the act complained of is innocent. So when the accused acted in obedience to the superior orders, especially they are military subordinates, no? They could not question the order of the superiors. And when they obeyed in good faith without being aware of their illegality, meaning to say yung order is not patently unlawful. They're not aware of their illegality, and without any fault or negligence on their part, the act is not accompanied by any criminal intent. So, can a crime be committed without criminal intent? Yes. Number one, if it's culpa. You know, kanina in my illustration, intent is not an element, but imprudence, negligence, lack of foresight, and lack of skill. So a crime may be committed even without criminal intent if it's culpa, and number two, if the crime is punishable under a special penal law. Okay, so let's go to the difference between crimes punished under SPL and that of the revised penal code, or it can also be the difference between mala inse and mala prohibita. Mala inse and mala prohibita. mala in se. Okay? These are crimes punished mostly applicable to special revised crimes punished under the revised penal code. Mala prohibita applicable to crimes punished under special penal laws. Or if you're asked either the difference between mala in se and mala prohibita, you can say first by saying, this is applicable to crimes punished under RPC if it's mala in se, or mala prohibita usually applies to crimes punished under SPL. But if the question is differentiate RPC from that of an SPL, you can state it, well, RPC is mala in se and SPL is mala prohibita as a general rule. No? This is not an absolute rule that lahat ng crimes under RPC is mala in se. When you talk about mala in se, you say that it is evil in its nature, no? Katulad ng rape, that's evil in nature. Taking the life of another person, like murder, it's mala in se, it's evil in its nature. Illegal possession of firearms, it's not mala in se because you can use a firearm to defend yourself. It's mala prohibita. No, before you can carry a firearm, you need to have a license. No, and what is punished is voluntarily breaching. No, that's the provision of the law that you have to secure a license. Now, mala in RPC is not always mala in se, like technical malversation or illegal use of public funds. Although it is punished under the revised penal code, no, technical malversation is mala prohibita. So therefore, good faith is not a proper defense. No? Like for example, kasi pag mala in se yan, good faith is a defense. Bago there is intent, criminal intent. SPL, no intent. So it's mala in se, it's then good faith is a defense to negate criminal intent. In mala prohibita, good faith is not a proper defense. Okay? So let's go back kanina in my illustration. So in technical malversation, although it's punished, and this is an exception, although it's an RPC, it's mala prohibita. Therefore, good faith is not a proper defense. Can you recall yung technical malversation or illegal use of public funds? When there is a law that allocates a particular a public fund, no, there's already a law or ordinance that allocates a particular fund for a particular purpose. And secondly, it was used for another purpose. It was used for another public purpose. And number three, no, it was used in a public purpose other than for which the law or ordinance intended it to be used. So halimbawa, there is a law that allocates a particular fund for the construction of the building. Now, since nagkaroon ng typhoon, it was used to rehabilitate. So therefore, good faith siya. There was no actual misappropriation on his part. But would that be a proper defense though? Because good faith is not a proper defense because it is deemed as mala prohibita. What about, will there be SPL that are not deemed mala prohibita but mala in se? Evil in its nature? Yes. No? Like a plunder. Plunder, although it's under the anti-plunder law, it's a special penal law, but Supreme Court said that it is mala in se. It is evil in its nature. Ergo, good faith is a proper defense. Next. No, the stages of execution. The stages of execution, consummated, frustrated, attempted, applicable here. no, in mala in se, so that the proper penalty can be imposed. But this is not considered in mala prohibita because it's deemed, the act is always deemed as consummated. So walang attempted stage sa mala prohibita unless the SPL uses the stages of execution. But the general rule, no, it's always on a consummated. So kung walang injury, attempted lang, no criminal liability. That was asked in the bar exam in the past. So remember that. Next, consummated, frustrated, attempted. Persons criminally liable. For the persons criminally liable, the principals, accomplices, accessories, they are determined in order to impose the proper penalty. Mala prohibita, no, the offender is deemed to be a principal. Generally. Unless of course, ang sabi ng SPL, it adopted also persons criminally such as principals, accomplices, and accessories. But in the absence of which, the offender is deemed to be a principal. No? Next. The mitigating, the ordinary mitigating and generic aggravating are considered in order to impose the proper penalty. In mala prohibita, it's not considered. No? So even if a person voluntarily, remember this may be asked in the bar exam. Even if the person voluntarily surrendered, even if he entered a plea of guilt, but it is mala prohibita, then sorry na lang. No? It's not considered, it will not be appreciated to lower the penalty because it's not applicable. What else? The nomenclature of penalties of the RPC, like RPC, like reclusion perpetua, reclusion temporal, no, we determine that for the proper penalty to be imposed in mala prohibita, no, because there is the law provides for specific penalty in its violation. However, no, there are SPL that uses the nomenclature of penalties of the revised penal code. Like yung child abuse. No? Child abuse, meron siyang mga reclusion, meron siyang prison. So, it has an effect. Why? Because in the imposition of ISLAW or indeterminate sentence law, no, the formula that will be used to obtain the maximum term and the minimum term of the indeterminate sentence is that of the RPC and not that of the special penal law. No? But generally, no, yung kung hindi ginagamit, kung hindi that fall by exception, it's not applicable because the law specifically provides for penalty. Just like reclusion perpetua. Differentiate reclusion perpetua from life imprisonment. Reclusion perpetua is a punishment under the RPC, imposed under the revised penal code. Life imprisonment is under special penal law. And the duration of penalty under reclusion perpetua is 20 years, 1 day to 40 years. Sa life imprisonment, malang ganon. Talagang life imprisonment siya. Okay? Let's clear all these drawings. So, remember, as a rule, attempted violation of a special law is not punished. Actual injury is required. Baka lang lumabas sa bar. Medyo feeling ko lang. Halimbawa, sa Anti-Graft and Corrupt Practices Act, wala namang injury sa gobyerno because it's only attempted. No, it's only attempted violation of a special penal law. It is not punished. Actual injury is required. Intent and motive. Lumabas sa bar. Differentiate intent from that of motive. Second question, when is motive relevant to prove a case? When is it necessary to be established? Several times this was asked na bar. M, no? Pag sabing motive, you start with M, letter M. Motive, moving power. It is the moving power which impels a person to do an act for a definite result. Moving power which impels a person to do an act for a definite result. What about intent? Intent is the purpose for using a particular means to bring about a desired result. Is motive an element of the crime? No, and motive is not an element of the crime, but intent is an element of intentional crimes. Motive, if it's attending a crime, always precedes the intent. So ang tanong, when is motive relevant to prove a case? Motive is relevant to prove a case in the following. Number one, kung may duda as to the identity of the offender, when there is doubt as to the identity of the offender. Second, when the act committed gives rise to variant crimes. Third, there is the need to determine the proper crime to be imputed against the offender. Note, it is not necessary to prove motive when the offender is positively identified naman siya. Hindi na kinakailangan. Or the crime did not give rise to variant crimes. Okay. Yon. So we already finished with the general principles. We will now go to the circumstances: justifying, exempting, mitigating, aggravating, and alternative circumstances. Let's go to justifying circumstances. Differentiate justifying from exempting. This is a favorite bar question. Bakit ayaw na siya? Yan. Sorry. Differentiate justifying under Article 11 and exempting is under Article 12 of the Revised Penal Code. Similarities. And so far similarities is concerned, there is no criminal liability to both of them. There is no criminal liability. But the justification is different. No criminal liability in justifying war. Why? Because the act is deemed to be in accordance with law. The act is lawful. So there is no criminal liability. In exempting, there is no criminal liability because of the absence of the element of voluntariness. Ito, justifying, lawful kasi siya. The act is lawful. In exempting is because of the absence of voluntariness. Tanggalin mo yung freedom. No, walang criminal liability. Like irresistible force. Irresistible force is an exempting circumstance. No? So wala siyang freedom. Minority. If the age is below, it's 15 or below. Absence of what? Intelligence. That's why there is no criminal liability. Next, what about their difference? There is civil, what about with respect to civil liability? With respect to civil liability, in so far as justifying is concerned, there is also no civil liability. In exempting, there is civil liability. So that's the difference. In effect, in justifying circumstances, there is no criminal liability as well as no civil liability. No, is that an absolute rule that there is no civil liability? No, there's an exception, which is paragraph 4 of Article 11. What about no criminal liability? Meron bang exemption? No, this is an absolute rule. In justifying and exempting, always no criminal liability. In civil liability, only a general rule. No, there is no civil liability except paragraph 4 of Article 11, which is what? State of necessity or avoidance of greater evil. That's the only instance na meron silang civil liability. In exempting, the general rule, on the other hand, is there is civil liability. Exception? Yes. If in justifying, paragraph 4 of Article 11, in exempting, meron ding exception, which is also paragraph 4, but of Article 12, which is accident, and paragraph 7. So in these instances, paragraph 4 and 7 of Article 12, there is no civil liability. So that's accident when he commits a lawful or an act lawful or for some insuperable cause. Okay. Let's go to specifically justifying. I hope you're still here with me. So we have self-defense. We have defense of a relative, and defense of a stranger. Okay, common element. There is unlawful aggression. Second, there is reasonable necessity of the means employed to prevent or repel the same. And there is lack of sufficient provocation. Magkasama yan, lack of sufficient provocation. It's not lack of provocation, it's sufficient provocation. When you talk about defense of relatives, the same element, the first two, except that the third, they differ. In case the provocation was given by the person attacked, then the person defending had no part therein. No part. So far as defense of stranger, the same. 2, unlawful aggression, reasonable necessity of the means employed to prevent or repel the same, except that he is not induced, hindi siya induced by revenge, resentment, or by some evil motive. If he is motivated by a revenge or by resentment or by some evil motive, then he cannot raise defense of stranger. Let's go to just an idea. Later on, I will be discussing in details. Unlawful aggression, when there is peril to one's life, limb, or property, when there's an actual threat upon a person. So unlawful aggression can be actual or imminent. When you talk about imminent, it should not be based on suspicion, but it should be at the point of happening. No? At the point of happening. Sa lahat, remember this, no? Sa justifying, sa defense of a relative, sa defense of a stranger, there must be peril on the life of the person that you are defending, that he is defending. If you're defending yourself, dapat may threat sa buhay mo. No, kung wala namang peril to one's life, there is no self-defense. Defense of a relative, dapat meron ding threat sa buhay, nanganganib yung buhay ng relative mo. No? And there is no peril to the life of your relative, then this is not applicable. And so also goes with this defense of stranger. His life must be in danger. If not, then if he's the aggressor, then he will be a co-principal. He will be a co-principal. Remember that. Reasonable necessity of the means employed to prevent or repel. The second one, ang sabi dito ay it's not based on a mathematical computation that if one uses if one uses a knife, that you should also defend yourself by using a knife. No, it's not. So there are two things that you have to consider. One is if it's if the person is acting under the impulse of self-preservation, no? And that if it is the only available means to defend himself, no, pwede yun, no? Could be considered as reasonable. Lack of sufficient provocation. Let me illustrate this. A person can claim self-defense on the following. If there is a provocation, you can still claim self-defense provided it is not sufficient. No, not sufficient. Ano bang sinasabi ng sufficient provocation? What is the meaning of sufficient provocation? So it is adequate to steer one to its commission. So and secondly, you can also claim self-defense if there is sufficient provocation, but it comes from a third person. So it's not between the victim and the accused, but it comes from a stranger or from a third person. Thirdly, a person can still claim self-defense if there is sufficient provocation, but it is not immediately preceding the act. If there is the presence of sufficient provocation, but it is not immediately preceding the act, then it's still deemed as you can still claim self-defense. So a person cannot claim self-defense or there is no self-defense if therefore there is sufficient provocation, but it is immediately preceding the act. If it is immediately preceding the act. So what's the difference? Si A sinampal si B, no? Pero sinampal niya yun, and it happened already 1 year ago. Nakita ni B si C. So gusto ni B bumawi. So he pulled the knife to kill A, but A successfully was able to parry it. He defended himself, no? And he killed B in defending himself. Now A claims self-defense. Sabi ng prosecution, hindi mo pwedeng i-claim ang self-defense kasi sinampal mo siya. Kung hindi mo sinampal si B at ipinahiya, no, before the people, then he will not he will not kill you. He will not plan to kill you or to retaliate. But in this case, it happened 1 year ago. So he's now able to recover his emotions. Unlike, say for example, if it happened on the same occasion and at the same time. Sa isang gathering, A without reason slapped B. And B felt embarrassed, and because of that he pulled a knife, and he is about to stab A, and A, lucky for him, was able to defend himself, to parry it, and killed B. Now the question is, can A claim self-defense? He cannot. Why? Because indeed it's immediately preceding the act. It happened right after slap that B pulled the knife, and if A would not have slapped him, then B would not have pulled his knife as well. So this is the difference between the two. Insofar as defense of a relative, the first and the second are present. The third element, in case the provocation was given by the person attacked, the person defending had no part therein. Dapat when he entered the scene of the crime, the life of his relative should be in danger. If there is no danger on the relative's life, then this is not applicable. There is no defense of a relative. If, say for example, he saw his brother stabbing another person who is already defenseless, and he helped his brother, he would now be deemed as a co-principal. Defense of a stranger, he should not be induced by revenge, resentment, or evil motive. If the purpose is actually to commit the act of revenge, then who would be liable? Okay. Let's go specifically na lang. Who are the strangers? Who are the strangers? Who are the relatives, I mean? Defense of relatives. Spouse, ascendants, descendants. Second, legitimate, natural, adopted brothers or sisters. Third is relatives by affinity. Relatives by affinity within the same degree. Anong same degree? Ito yun. Okay, could be a parent-in-law, a son-in-law, a brother-in-law, a sister-in-law. And fourth will be relatives by consanguinity within the fourth civil degree. So refers to the first cousin. If you're defending your second cousin, it will not fall under defense of relative. But don't automatically say defending a second cousin is a defense of a stranger. No, not automatically. You can say it may fall under defense of a stranger, provided that he is not induced by revenge, resentment, or some evil motive. Now, so if you defended the child of your first cousin, still it will not fall under defense of a relative. So these are only the relatives. Of course, yung affinity, it must be existing. Dapat hindi na, kung namatay na yung halimbawa, yung wife niya, wala naman silang anak, and then he's remarried, then wala na silang tapos na yung nila, relatives by affinity. So again, let's just discuss all the specifically defense of self-defense. Right included in self-defense, it includes not only defense of the person or body of the one assaulted, but also that of his rights. No? Those rights, the enjoyment of which is protected by law. So aside from the right to life on which rests the legitimate defense of our person, We have the right to property acquired by us and the right to honor, which is not the least price of man's patrimony. So to prove self-defense, the accused must show with clear and convincing evidence that hindi ikaw ang unlawful aggressor, that he was not the unlawful aggressor, that there was lack of sufficient provocation on his part, and third, he employed reasonable means to prevent or repel the aggression. The scope includes self-defense not only of life, no, pero applicable din ito to rights like like those of chastity, o kaya property and honor, and it has been applied also to the crime of libel. So there is self-defense of chastity. So to be entitled to a complete self-defense of chastity, there must be attempt to rape, and it is not necessary that the actual act be committed, as the imminence thereof will just justify the woman to kill the offender if he has no other means to defend himself. Pero kung tapos na, that's another story, right? Defense of property. Pagka-defense of property, it is necessary that there must be an attack on the property coupled also with the attack on the person of the one entrusted with said property. Self-defense in libel. When a person is libeled, he may hit back with another libel, which, if adequate, will be justified. In physical assault, no, retaliation is unlawful after the attack has ceased, but not in the case where it is aimed at a good person's good name. So once the aspersion is cast, its sting clings, no? It remains, and the one thus defamed may avail himself of all the necessary means to shake it off. The law is clear that unlawful aggression must come from the victim. So, aggression must be unlawful. Halimbawa, paano yung paramour? Paramour surprise in the act of adultery cannot invoke self-defense if he killed the offended husband who was assaulting him. Sinabi ng Supreme Court yon. At ang sabi ng Supreme Court, kahit na daw true, and even if the deceased did succeed in entering the room in which the accused at yung deceased wife were lying, no? Nakaiga pareho sila, and did immediately, pagkatapos nakita, no, assaulted the accused, giving him several blows with the bolo. That assault was deemed, sabi ng Supreme Court, natural lang yan and lawful for the reason that it was made by a deceived husband, no? And in order to defend himself, he had to kill his wife and the accused. And if they were caught in the act of sexual intercourse, he would have exercised a lawful right, no? It would fall under, kung naalala nyo, Article 247 of the RPC. The unlawful aggression, because there was no imminent and real life danger to life or limb of the accused. As I've always emphasized a while ago, if there is no imminent or peril or real danger to the life and limb of the accused, there is no unlawful aggression. So retaliation, is retaliation a self-defense? You know this already. No, retaliation is not a self-defense because the aggression that has begun by the injured party already ceased to exist when the accused attacked him. In self-defense, the aggression dapat must still be existing when the aggressor was injured or disabled by the person making a defense. Okay, remember also that the unlawful aggression must come from the person who was attacked by the accused. And the nature and the character, location, extent of wound of the accused allegedly inflicted by the injured party may claim may belie the claim of self-defense. Paano nangyari ito? In number of wounds received by the deceased, halimbawa, 20 in number. So yung plea ng self-defense, you cannot seriously entertain that. O kaya, when the aggressor flees already, no? Unlawful aggression no longer exists. If he runs away already, wala na yun. No? The one making a defense has no more right to kill or even to wound that person or that former aggressor. But it's different when there is retreat. So titingnan nyo. Retreat to take more advantageous position. That's not running away. That's not fleeing. So if it is clear that the purpose of the aggressor in retreating is to take a more advantageous position to ensure the success of the attack already begun by him, the unlawful aggression is still considered continuing. And the one making the defense has the right to pursue him in his retreat and to disable him. If there's agreement to fight, no unlawful aggression. Kaya lang tingnan nyo, dapat the challenge to a fight must be accepted. Now let's look into certain bar examination suggested answers. We don't have the time already to look into the questions. But from the suggested answers, you can already see how the law was applied. Like in one case, suggested answer. No, the accused claim of self-defense of honor should not be sustained because the aggression on her honor had ceased when she stabbed the aggressor. Under the law, unlawful aggression must be continuing when the aggressor was injured or disabled by the person making a defense. So ito, baka tanungin kayo, medyo similar to this one, at least you know this. So if insofar as defending one's honor, it should not, unlawful aggression should not cease already. Otherwise, she cannot trace that. No. As I've said, with respect to reasonableness of the necessity depends upon the circumstances. Number one, necessity of the course of action taken. Second, necessity of the means used. The test of reasonableness of the means used will depend on the nature and quality of the weapon used by the aggressor, yung kanyang physical condition, character, size, and other circumstances, and those of the person defending himself, and also the place and occasion of the assault. No? Pero pagka dawan ang involved is a peace officer, iba na yung rule. So what is the rule regarding the reasonableness of the necessity of the means employed when the one defending himself is a peace officer? Unlike private individual, yung peace officer has the duty, and it requires him to overcome his opponent. Third requisite, lack of sufficient provocation. Sufficient means proportionate to the damage caused by the act and adequate to steer one to its commission. Who are deemed as strangers? Any person not included doon sa paragraph 2 of this article, is considered a stranger. Now, remember again, the third requisite will be lacking if such person was prompted by his grudge against the assailant, because the alleged defense of the stranger would only be a pretext, kunyari, ginamit niya lang. One bar problem, ang suggested answer is this, A may invoke the justifying circumstance of defense of a stranger since he was not involved in the fight and he shot C while the latter was about to stab B. and there being no indication that A was induced by revenge, resentment, or other evil motive in shooting C, his act is justified under Article 3, Article 11, Paragraph 3 of the RPC. The fourth is, di ba, self-defense, defense of a relative, defense of a stranger. Number 4 of justifying is avoidance of greater evil. Damage to another. The term includes also or covers injury to persons and damage to property. That the evil, sabi sa batas, that evil sought to be avoided actually exists. So requirement is that the evil must actually exist. If the evil sought to be avoided is merely expected or anticipated or may happen in the future, that is not applicable. And also, tandaan nyo, yung greater evil should not be brought about by his negligence or imprudence of the actor. Also, when the accused was not avoiding any evil, so he cannot invoke this justifying circumstance of avoidance. No? So the evil which brought about the greater evil must not result from a violation of law by the actor. No? Hindi dapat result from a violation of the law by the actor. So state of necessity exists kung merong clash between two unequal rights. The lesser right giving way to a greater right. The state of necessity must not be due to negligence or violation of any law. No? So this is the only instance yung sinabi ko kanina that there is civil liability. No? But this is borne not by the actor but by the person or persons benefited by his act. So yung isang illustration dito, when the fiancé, no, the girl, no, did not appear during the marriage, the celebration of marriage, because she realized that she actually does not love this guy. Preparations were already made. Marami nang ginastos si guy, no? The wedding, the payment for the church, and also sa lahat, no? And because of that, the guy filed a case of slander by deed, no? And she raised the defense of avoidance of greater evil. What is the greater evil? The greater evil is entering into a loveless marriage. So, in this case, accused can be acquitted of the crime of slander by deed, no? After all the wedding preparations with the offended party were made, since there was a necessity on the part of the accused to avoid going to a loveless marriage with the offended party, but she can be liable for civil liability. Fifth, under the justifying circumstance, fulfillment of duty or lawful exercise of right or office. Requisites. Number 1, the accused acted in the performance of a duty or in the lawful exercise of right. Let me check on yan. I can show you the codal provision. That we are now in number, we finished with number 4. Now we are now about to discuss on Paragraph 5. Any person who acted who acts in the fulfillment of a duty or the lawful exercise of a right. Lawful duty or exercise of one's right. The accused acted in the performance of a duty or in the lawful exercise of a right, and that the injury caused or the offense committed be the necessary consequence of the due performance or the lawful exercise of one's right. So, papasok dito yung Article 429. The doctrine of self-help. So, the owner of or possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he can use reasonable force necessary to prevent or repel an actual or threatened unlawful physical invasion or usurpation of his property. Yeah. It is not necessary that there must be unlawful aggression against a person charged with the protection of the property. If there is unlawful aggression against the person charged with the protection of the property, ang mag-a-apply dyan ay paragraph 1 ng Article 11. It being the defense of a right to property. Let's quote some suggested answers here. No? In one case, ang sagot sa bar question is that the accused did not incur criminal liability because his act of firing at the rear wheel of the car to stop the vehicle and prevent P from taking away his car is neither done in dolo daw or in culpa. The act does not constitute a crime. It is reasonable exercise of his right to prevent or repel an actual physical invasion. In one bar exams, ang suggested answer is here. A is not criminally liable. Yung service pistol was snatched by another person. A was only in the lawful exercise of a right in trying to regain its possession, and there was no negligence on his part. Another bar question, but suggested answer in a bar question, but not constituting fulfillment of a duty. Sabi ng suggested answer is that the defense of the police is not tenable daw. Kasi yung defense of having acted in the fulfillment of a duty requires that it is not enough daw that the accused acted in the fulfillment of duty. Because in this case, after the victim was shot in the right leg and he was already crawling, there was no need again for that policeman to shoot him further. Now, clearly, that policeman acted beyond the call of duty, which brought the cause of the death of the victim. So let's go to number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Requisites. Order by a superior order must be for some lawful purpose. The means used by the subordinate to carry that such order is lawful. In other words, lawful order, lawful means. Both the persons who give the order and the person who executed it must be acting within the limitations prescribed by law. But even if the order is illegal, if it is patently legal and the subordinate is not aware of its illegality, the subordinate is not liable, as I mentioned a while ago. But in one case, when the military officer instructed or ordered his subordinates to kill their prisoner of war, and they followed, No, their boss, their officer, can they claim obedience to an order? No, they cannot, because they know that the order is patently unlawful, because every soldier should know that there is no justification to kill. At no instance can a prisoner of war be killed. They know that as soldier, no, under Geneva Convention. Let's go to exempting circumstances. Okay. Yun. The exemption from punishment is based on the complete absence of intelligence, freedom of action or intent, or absence of negligence on the part of the accused. In exempting circumstances, there is a crime, but there is no criminal liability exists. Imbecility, how do you distinguish that from insanity? Imbecile is exempt from crime in all cases, sa lahat ng pagkakataon. No criminal liability. Why? Because an imbecile is one who, while advanced in age, has a mental development comparable to that of children between 2 and 7 years of age. While insanity is not, insane person is not exempt if it can be proven that he acted during a lucid interval, or during the lucid interval, the insane acts with intelligence. Question ngayon, sino ang may burden to prove insanity? Who has the burden to prove or to show insanity? The defense must show or must prove that the accused was insane at the time of the commission of the crime, because the presumption is always in favor of sanity. How much evidence is necessary to overthrow the presumption of sanity? When a person was insane at the time of the commission of the felony, he is exempt from criminal liability. Lumalabas sa bar to. Pagka insane siya at the time of the commission, walang problema. Pero kung sane at the time of the commission of the crime, pero he became insane only later after the commission of the crime or during trial, he is criminally liable. Ang consequence, masususpend lang ang trial, no? Kung naging insane siya at the time of trial, but sane at the time of the commission of the crime, he is liable. Okay? So the evidence of sanity must refer to the time preceding the act under prosecution or the very moment of its execution. Let's go to number 4. Performing a lawful act. No? Accident. Requisites. Performing a lawful act, due care, exercise with due care. He causes injury to another by mere accident at dapat walang fault or intent of causing the same. So what is an accident? An accident is something that happens outside, that's way of our will. And although it comes about through some act of our will, lies beyond the bounds of humanly foreseeable consequences. So if the consequences are plainly foreseeable, it will be a case of negligence. Remember this one, no? Irresistible force. Irresistible force. The force must be a physical force. It must come from a third person, and that it must be irresistible force. So it's not a threat, no? Hindi katulad ng paragraph 6, no? Kasi ito merong physical force being exerted. No, katulad ng pagbayro ng baril sa head ng isang accused, and the accused was required to kill his companion, otherwise he will continue to hit his head. He is exempted from criminal liability because of irresistible force. But with respect to uncontrollable fear of an equal or greater injury, that's another thing. No, there must be a threat. Number one, there must be a threat which causes the fear of an great evil greater than or at least equal to that which is required to commit. No? And it promises of an evil with such gravity and imminence that ordinary man would have succumbed to it. No? Basis of duress as a valid defense, no? It must be based on real, imminent, reasonable fear for one's life or limb, and it should not be inspired by only a speculation or remote fear. How do we distinguish these two? As I've said, sa paragraph 5, merong physical force. Sa paragraph 6, no, employs intimidation or threat in compelling another to commit a crime. Okay? Basis of paragraph 6, no, under uncontrollable feel, an act done by me against my will is not my act. An act done by me against my will is not my act. Actus me invite, factus non est meus actus. And lastly, number 7, no, when prevented by some lawful or insuperable cause, no, that the requisites, the act is required by law to be done, person fails to perform such act, its failure to perform was due to some lawful or insuperable cause. So a person who arrested a police officer who arrested a suspect, no, in the mountain, and there's no means of transportation in going down. No, you know that a person may be liable for arbitrary detention because he has to deliver, to file a case against him, deliver to a judicial authority within the number of hours required by law. And if he fails to do that because there is no means of transportation, then he can raise this to exempt him from criminal liability. Merong lumabas na mga bar questions dyan. No, yung if he was not insane at the time of the commission of the crime. The facts of the case, however, indicate that the accused acted or committed the crime with discernment. So, yun ang mga analysis in a particular bar question. Yung isa, sabi niya, the court is correct in ruling out insanity as an exempting circumstance, while there was a testimony that A was suffering from a mental disorder. The testimony of A's father disclosed that A had lucid interval. No? And because what is presumed is insanity, not insanity, it is to be presumed that A was insane when he committed the crime. When a person uses a high-powered M16 rifle and use it for hunting, he committed a crime of illegal possession of firearms as he does not appear to have either a license. No? And furthermore, that it is a high-powered, he was negligent in not seeing that bullets fired from his gun may ricochet. Let's go to mitigating circumstances. How do you differentiate? Ito lumalabas sa bar. So you have to remember this. Mitigating and aggravating. Kinds, you have ordinary, and you have privilege. Aggravating, you have generic, you have specific, you have qualifying, and you have number 4, inherent. So let's go to mitigating circumstances. Two kinds of mitigating. You have ordinary and privilege. Ordinary, if present, and no generic aggravating circumstance, it will reduce the penalty to its minimum period. While in privilege mitigating, if present, the penalty will be reduced by 1 or 2 degrees lower. Another difference between the two. In ordinary mitigating, it can be offset by any generic aggravating. In privilege, it cannot be offset by any aggravating circumstance. Okay? Now, aggravating circumstances. We got generic. If present without any mitigating, would increase the penalty to its maximum period. No? Period. Pag sinabing period, so ibig sabihin, applicable ang generic to divisible penalties as well as ordinary. No? Specific, it applies to particular crimes. Qualifying, it changes the nature of the crime. Like murder, homicide, if the qualifying aggravating circumstances under Article 248 are present, such as treachery, evident premeditation, and the others, the crime would not be homicide aggravated, but it's murder because it's used as a qualifying aggravating. Inherent in the commission of the crime. Robbery in evident premeditation. Evident premeditation is inherent in the crime of robbery. In malversation, abuse of public position is inherent. What's the important is that in the rule of offsetting, you only offset between an ordinary from that of a generic aggravating circumstance. The only between these two. Privilege, you do not offset. No. Why? Because once you see the privilege, you lower it down by 1 or 2 degrees, usually by 1. Kung nakita nyo circumstances, they have ordinary mitigating, generic aggravating, privilege mitigating. What you do once you see a privilege, you lower it down by a degree. Then you apply the rule of offsetting. And the rule only applies between an ordinary and generic aggravating. Ordinary cannot offset specific. It cannot offset a qualifying. It cannot offset an inherent one to increase the penalty its maximum period. So, halimbawa, the use of fire, it cannot be offset because it's a crime in itself. As I mentioned, abuse of public position, you do not increase the penalty to its maximum period when the crime is malversation, because abuse of public positions is inherent in the crime of malversation. Robbery with force upon things, evident premeditation cannot be offset by any ordinary mitigating. Why? Because it's inherent na yan eh. So dapat, you know how to distinguish. Do not immediately offset once you see an aggravating. Make sure that it's a generic aggravating. And make sure that also it's an ordinary mitigating, because it's a privilege. Automatically, you lower the penalty. Okay, let's continue. Kailangan medyo bilisan natin. The first one, incomplete self-defense. Okay, incomplete, no? What's the first one? Incomplete justifying, like incomplete self-defense, unlawful, three requisites, no? As we mentioned kanina, unlawful aggression, reasonable necessity, lack of sufficient provocation. If unlawful aggression is present, treat it only as an ordinary mitigating. But if unlawful aggression is present, plus reasonable necessity, o kaya lack of sufficient provocation, 1 and 2 and 1 and 3, it becomes a privilege mitigating. And when it becomes a privilege mitigating, you lower it down by a degree. No? It cannot be offset by any generic aggravating. So pag 1 and 2 and 1 and 3 are present, it cannot be offset, lower it down by degree. So you have to analyze the bar problem. Pag nakita mo 1 and 2, 1 and 3, privilege yan. Baba mo ay 1 degree. Pag unlawful aggression lang yan and you see an generic aggravating, it can be offset. But if it's 2 which is present, it has no bearing. No, it will not lower the penalty. If only 3 is present or lack of sufficient provocation, it's immaterial. It has no bearing. Or if even if 2 or 3 are present without any unlawful aggression, no, it will not affect the penalty. It will not lessen the penalty because unlawful aggression is the indispensable requisite. When you talk about minority, if the is minority a mitigating, is minority an accepting circumstance? It depends. Don't say that it's automatically an exempting. Minority can either be an exempting, and it could either be a mitigating. If the age of the child, number 1, is 15 years old or below, when you say 15, birthday niya. Because if his age is 15 years old and 1 day, that's already above 15. No? So 15 or below, total exemption. You don't even have to determine whether he acted with or without discernment. Second, if the age of the child is above 15 and below 18, no, it's exempting if he acted without discernment. If he does not know the consequences of his act, above 15 or 15 days, 15 years old and 1 day, and below 18, just a day before his birthday, 18th birthday, and if he acted without this discernment, he is exempted, or that he does not know the consequences of his act. But if the child is above 15 or below 18, no? Above 15, below 18, and he acted with discernment, he is criminally liable. No? It is not exempting. But if he acted with discernment, it will be deemed as a privilege mitigating, and he is entitled to lessen the penalty, not in its minimum period, but by a degree. Let's continue. No intention, number 3, no intention to commit so grave a wrong. It refers to praeter intentionem. No, the injury is greater than that he intended. Number 4, sufficient provocation. No, provocation must be sufficient. It must originate from the offended party. Provocation must be immediate to the act. No, immediate means no interval of time. Sometimes when this is asked in the bar, you differentiate paragraph 4 from paragraph 5. Paragraph 4, sufficient provocation on the part of the offended party immediately preceding the act. So there's a word immediate. Number 5, if you notice, the act was committed in the immediate vindication. So both paragraphs 4 and 5 use immediate, the word immediate. But number 4, as contemplated, immediate therein is that there is no interval of time. When you talk about immediate under paragraph 5, which is immediate vindication of a grave offense, no, means proximate. There can be an interval of time may lapse from the commission of the grave offense to the commission of the crime in vindication. So remember that. What else is the difference between the 4 and the 5? It aside from proximate and not proximate. Okay, there under number 5 there could be a grave offense. Under number 4 wala. Grave offense that can be done against himself or against his relatives. The relatives, no, is only up to relatives by affinity within the same degree. It does not mention about relatives within by consanguinity within the 4th civil degree. So remember that, no? Grave offense may not be a crime. It could be for as long as something wrong is committed against the family or against himself. Okay, what else? There are a lot of questions here as a immediate vindication. No? Halimbawa, one was asked, no, W allowed a man to have sex with her thinking that she was her husband. Tapos na she realized that the man was not her husband. So she stabbed him to death. No? Kaya lang tapos na, no? So hindi na justifying. It can be mitigating. What type of mitigating? Immediate vindication of a grave offense, no? Another question, kung itatanong sa bar, ito lang yun, no? A cannot be validly invoked, the accused cannot validly invoke defense of his daughter's honor in having killed B since the rape was already consummated. And moreover, B already ran away. So there was no aggression to speak of, no defense of honor. But A can invoke, however, the benefit of the mitigating circumstance of immediate vindication of a grave offense to a decedent, to a descendant. Yun. Next, passion and obfuscation. Having acted upon an impulse so powerful as naturally to have produced passion and obfuscation, kailangan no passion or obfuscation after 24 hours or several hours, no? Kasi dapat yung the said act which produced the obfuscation was not far removed from the commission of the crime by a considerable length of time. Dapat ang passion of obfuscation, we know this, it must arise from a lawful sentiment. A legitimate feeling. So merong illegitimate feeling. So if the husband, no, he has a wife and then he has a girlfriend and then yung girlfriend niya nag-betray sa kanya, went with another man, he killed this girl, can he raise passion and obfuscation in killing this girl because she loved this girl so much, but more than he loves his wife? No, he cannot, because it arises from his illegitimate feeling, not from a lawful sentiment, no? No, magkaiba yung passion obfuscation from irresistible force. Passion obfuscation, mitigating lang yan. Irresistible force is an exempting. Okay? Voluntary surrender. To whom? To Ted Pailon? Hindi. Kasi it can only surrender to a person in authority or an agent of a person in authority. Second, the surrender must be voluntary. Third, the offender had not been actually arrested. So the surrender must be, again, to a person in authority or an agent of a person in authority. Hindi pwede kay Montulpo. Ang voluntary surrender, he acknowledges his guilt. He wishes to save time and trouble and expense in searching him and capturing him. If it's just a matter of time, kahit hindi siya nag-surrender, pero mahuhuli rin siya, this will not be considered. If his purpose is only to verify to the police station kung it is true that he heard the news that he is wanted by authorities, not voluntary surrender. No? Question, voluntary surrender is a mitigating circumstance in all acts and omissions punishable by the RPC. True or false? It's false because of voluntary surrender may not be appreciated in case of criminal negligence. Okay. Plea of guilt. Plea of guilt, it must be spontaneous. Confession in open court. Maraming bar problem dito. No, it should be done in open court or before the competent court that is to try the case. And of course, the confession must be made prior to the presentation of the evidence for the prosecution. Plea of guilt on appeal cannot be mitigating. Plea of guilt at the preliminary investigation is no plea at all. And of course, the confession of guilt must be made in open court, no? And not an extrajudicial confession. Plea of guilt. May mga questions. Baka may tanong sa bar. Allow me to quote some suggested answers. He entered his plea of guilt before the RTC can be considered daw as spontaneous because that is the court trying his case. But his plea of guilt in the MTC, which is conducting a preliminary investigation only, it cannot be considered because it is not a court competent to render judgment. Hindi pwede kay fiscal o hindi pwede sa MTC conducting a preliminary investigation. It should be the court which can render a judgment. Pwede bang mag-plea of guilt when the crime charge is illegal possession of firearms? As I've said, hindi, because it's a special penal law. Remember the basic difference between an SPL from that of the RPC. Neither is plea of guilt a mitigating circumstance because a confession of guilt must be done before the prosecution had started to present its evidence, not after. Okay, number 9, number 8, physical defect, deaf, dumb, blind. Physical defect must restrict his means of action, defense, or communication of his fellow being. Physical defect is such as being armless or crippled, whereby his means to act or defend himself or communicate with his fellow beings are limited. So the nature of the offense to be considered as such is dapat it would affect his means to act, defend, or communicate with his fellow beings. No? Halimbawa, yung bang commission ng blind ng estafa by misappropriating entrusted by a friend for safekeeping, entitled him to mitigating? Hindi. Di ba? No, walang kinalaman ng pagiging blind niya. Sa crime of treason, hindi rin. We're not mitigating. No? If he commits the crime of injuries, a crippled man, pwede. No? Illness. illness must diminish, number 9, the exercise of his willpower, and it must not deprive him of the consciousness of his acts. When the offender completely lost the exercise of a willpower, it may be an exempting circumstance. Okay. Analogous. Analogous over 60 years of age with failing eyesight, similar to over 70 years of age. Outrage feeling of creditor, similar to passion and offuscation. Impulse of jealous feeling, similar to passion offuscation. Voluntary restitution of stolen property, similar to voluntary surrender. Extreme poverty and necessity, similar to incomplete justification based on state of necessity. Condition of running amok, nag-amok siya. No, not mitigating. Okay, let's go to aggravating circumstances. We only have a few, kaya pa. Gaya ng sinabi ko, as I mentioned to you, just concentrate when we're already in the rule of offsetting, you only apply the generic aggravating circumstance to offset an ordinary mitigating. Do not apply specific, do not apply qualifying, do not apply inherent, because they cannot be offset by any ordinary mitigating circumstance. No? Let's go to advantage be taken of his public position. Titingnan nyo lang, it should be generic aggravating, not inherent. Okay? So as I've said, this is inherent in the crime of malversation or bribery. Do not use it to offset a generic, ordinary mitigating. It will not be low. It will not lower the penalty. It will not increase the penalty to its maximum period. Advantage. Ang tanong lang dito, did the accused use his public position in order to commit the crime? If yes, no, unless it's inherent or other aggravating though, then appreciate the same. If he did not use or did not take advantage of his public position, and then this is not to be appreciated. Okay. The second, the crime be in contempt or with insult to the public authority. Dapat yung public authority is engaged in the exercise of his function. That he who is thus engaged in the exercise of function is not the person against whom the crime is committed. No? Ang public and the offender knows him to be a public authority. And his presence has not prevented the offender from committing the crime. Pag sinabing public authority, sino ito? No, it is called a person in authority. So one is directly vested with jurisdiction. So kung sa police officer, the crime was committed in the presence of the police officer, this is not applicable. And dapat kilala, and the offender knows that he is a person in authority, and it did not dissuade him from committing a crime. Bawa si barangay chairman, inawat niya si A and B sa barangay niya. Yet A killed B in the presence of the barangay chairman. This is applicable. No? Now, if the assault is directed against the barangay chairman, then this is not an aggravating anymore. That is a crime already, direct assault. So again, do not appreciate this when it is committed in the presence of that agent of a person in authority only. And knowledge that a public authority is present is essential. Number 3, insult due to rank, age, or sex, or the crime is committed in the dwelling. This is applicable only to crimes against persons or honor. The circumstance of rank, age, or sex may be taken into account only against persons or honor. With insult or disregard, there must be evidence that in committing the crime, the accused deliberately intended to offend or insult the sex or age of the offended party. Fourth, the act be committed with grave abuse of confidence or ungratefulness. No? Dwelling muna. Dwelling. The owner of the dwelling who gave the provocation. What if the owner of the dwelling is the one who gave the immediate provocation? Dwelling is not aggravating in this case. Prosecution must prove that no provocation was given by the offended party. Also, even if the offender did not enter the dwelling, this circumstance is applicable. So, halimbawa, although the triggerman fired the shot from outside the house and the victim was inside, then it is still applicable. It is enough that the victim was attacked inside the house, although the assailant may have devised means to perpetrate the assault from outside. So dwelling is aggravating even if the offender did not enter the upper part of the house where the victim was, but shot from under the house. Pwede yun. Even kahit na yung killing took place outside the dwelling, sa labas na, but provided that the commission of the crime was begun in the dwelling, nagsimula sa loob ng bahay, napatay outside the house, still appreciated. When the victim had two houses in which he used to live, the commission of the crime in any of them is attended by this one. Pero dwelling is not aggravating in these instances where both the offender and the offended party are occupants of the same house. And this is even true if the offender is a servant in the house. Second, when the robbery is committed by the use of force upon things, dwelling is not aggravating. Bakit? Kasi it is already inherent. Dwelling is inherent sa robbery with the use of force upon things. In the crime of trespass and dwelling, tatandaan nyo, inherent ito. Huwag nyo nang i-increase sa penalty to its maximum period. Do not use this to offset an ordinary mitigating. No? When the owner of the dwelling, as I've said, gave the provocation and do not appreciate this. When this is present, when the husband killed his estranged wife in the house occupied by her, other than the conjugal home. Abuse of confidence. Number 4, that the party had trusted the offender and the offender abused such trust by committing a crime against the offended party. Abuse of confidence must facilitate the commission of the crime. Pag hindi na facilitate the commission of the crime, then do not appreciate this one. Bar problem, importante yun. The confidence between the offender and the offended party must be immediate and personal. Immediate and personal. No, the one who offended, who had been the offender must offend the offended party, not the other person. Halimbawa, the father entrusted his child to his best friend, who is a minor, and the father went abroad. His best friend molested his child. Question, is there abuse of confidence? No, because again, as I've said, it must be immediate and personal. Who is the person offended? Is it the father or the child? It's the child. Between the child and the father's best friend, is there a trust and confidence? No. So it should be the father who should be offended by his best friend and not the child. Abuse of confidence inherent in some felonies and do not appreciate that. Inherent in malversation, inherent in misappropriation and qualified seduction. Okay, number 5, committed in a palace or place dedicated to religious worship, the place where public authorities are engaged in the discharge of their duties, distinguished from contempt or insult to public authorities. In both instances, public authorities are in the performance of their duties, but under paragraph 5, the public authorities who are in the performance of their duties must be in their office. Doon sa paragraph 2, which we discussed earlier, they're not performing, they're performing outside of their office. In paragraph 2, the public authority should not be the offended party. Dito sa paragraph 5, he may be the offended party. Now notice dito, no, in the place dedicated to a religious worship, no, or in the palace of the chief executive, place lang ito, no? Hindi na kinakailangan ng official or religious functions, not necessary. Number 6, nighttime, uninhabited place. Or ban, NUB. Dapat it should facilitate the commission of the crime or especially sought for. No? Nighttime to be appreciated, aggravating, it facilitated FES, facilitated the commission of the crime, especially sought for by the offender, and took advantage thereof. Pag hindi naman, they did not take advantage of it, wala. Nighttime darkness, the period of darkness beginning at the end and dusk. No, night, not aggravating when crime began at daytime. Dapat the commission of the crime must begin and must be accomplished under the concealment of darkness. It must be accomplished during nighttime. And that the offense must be actually committed in the darkness of the night. Uninhabited place. It's not the distance, but whether or not the place of the commission of the offense there was a reasonable possibility of receiving help. No? Possibility of the victim receiving some help. What is a ban? Whenever more than 3 armed malefactors shall have acted together in the commission of an offense. More than 3, so there should be at least 4. No? If one of the 4 armed persons is a principal by inducement, they do not form a band. By a band is aggravating against property or against persons or in the crime of illegal detention or treason. This is not applicable to crimes against chastity. No? And by a band is also inherent sa brigandage. No? Occasion of 7, conflagration. Number 7, offender must take advantage of the calamity or misfortune. Yun lang. He took advantage. If it's just a coincidence, it's just casual, no, hindi. Dapat he should take advantage of the calamity or misfortune. Number 8, aid of armed men. No? Yung accused availed himself of their aid or relied upon them. Kung casual presence lang, near the commission of the crime, hindi magko-constitute. No? Kung pareho silang armed, hindi, this will not be considered. What else? A recidivist. Who is a recidivist? Previously convicted by final judgment of another crime. What is controlling is at the time of trial. No, not at the time of the commission of the crime. No, at the time of the trial, no, hindi yung commission of the crime, time of the commission of the crime. It is not required that at the time of the commission of the crime, the accused should have been previously convicted by final judgment of another crime. And when you say previously convicted by final judgment, no, it must be the present crime and the previous crime must be embraced in the same title of the code. Pardon does not obliterate the fact that the accused was a recidivist, but amnesty extinguishes the penalty and its effects. We'll talk about number 10, reiteration, previously served sentence. Ito naman, served sentence. How do you distinguish recidivism from reiteration? Itong reiteration, it is necessary that the offender should have served out his sentence for the first offense. In recidivism, it is enough that the final judgment has been rendered in the first offense. Second, in reiteration, the previous and subsequent offenses must not be embraced in the same title of the code. In recidivism, as I've said, it must be embraced in the same title of the code. Third, reiteration is not always an aggravating circumstance, whereas recidivism is always to be taken into account in fixing the penalty to be imposed. Price, reward, or promise, it presupposes the concurrence of the two offenders. The price or the reward or the promise must be for the purpose of inducing another to perform the deed. By number 12, the crime be committed by means of inundation, fire, etc. Unless used by the offender as a means to accomplish a criminal purpose, any of the circumstances in paragraph 12 cannot be considered or appreciated to increase the penalty. Dapat yan, ito ay used by the offender to accomplish a criminal purpose. Evident premeditation. It must be evident. Premeditation must be evident and not merely suspected. Requisites, TAL, the time that he determined to commit the crime. A, act manifestly showing that he clung to his determination to commit the crime. He has the opportunity to meditate or reflect upon the consequences of his act. Letter L, sufficient lapse of time between the determination and execution of the crime. So, importante, the time and date when the offender determined to commit the crime. They are essential. Ano mga example? Yung crime was carefully planned by the offenders, nag-previously prepared the means when they considered adequate to carry out. Yung grave, prepare na nila, no? Pag pinatay nila, kung saan nila lilibing. Okay, when the defendant already commenced to sharpen his bolo in the afternoon, the night before he committed the crime, no? Those are examples. When the victim is different from that intended, evident premeditation is not aggravating. Treachery, importante to. Even when we discuss murder, because it's a qualifying circumstance of murder, treachery, among others. Of course, evident premeditation and yung iba pa. Mode of attack, dalawa lang. The attack must be sudden and unexpected. No, the attack must be sudden and unexpected, such as the victim had no opportunity to defend himself. Victim had no opportunity to defend himself because the attack is sudden and unexpected. Number 2, It must be consciously and deliberately adopted to ensure its execution. These two must concur. Hindi pa pwedeng isa lang. The mode of attack must be consciously and deliberately adopted to ensure its execution, to eliminate self-defense on the part of the victim. So the mode of attack must be thought of by the offender. It must not spring from the unexpected turn of events. So kung ang decision niya is only a spur of the moment, it was sudden, there's no treachery, no? O kaya ang meeting between the accused and the victim is casual lang, no? Hindi, it's not also considered. So anong mga examples ng not opportunity to defend himself? Like attack is sudden, we're in the act of shaking hands, and then all of a sudden he was stabbed by the accused. Or when the person was texting, stabbed also by the accused, no? But there's no treachery when the victim was already defending himself when he was attacked by the victim, and where he was given a chance to prepare himself, no? Such as there was a challenge to a gunfight, no? No treachery also when it was preceded by a warning, or shooting is preceded by a heated argumentation or discussion. Okay? Or appraise ang hands niya, there is treachery. Treachery in killing there is also treachery in killing a child. Can there be treachery even if the attack is face-to-face? Yes. If it is sudden and unexpected, no opportunity to defend himself, and it should be consciously and deliberately adopted. No? What you have to remember here is what are the circumstances where treachery can absorb. No? What circumstances treachery may absorb? Treachery may absorb abuse of superior strength, aid of armament by a band, means to weaken of defense. Pag nagsama-sama yan, ilalagay mo na sa treachery. Nighttime, treachery, absorbed by treachery. What about craft? Absorbed by treachery. Age and sex, absorbed by treachery. But dwelling is not included, no, in treachery. Treachery is inherent in murder by poisoning. Of course, treachery cannot coexist with passion or obfuscation. Okay, ignominy. When you talk about ignominy, unang add mo dyan is that merong the purpose is to humiliate, to put the victim to shame, the offended party. So when they were required, when the wife was raped in the presence of the husband, or when they were required, the offended party, the victim, were required to kneel down before the accused. Dati lang nilang trabahador yung accused, and this person shot these two persons, yung husband and wife. Applicable to crimes against chastity, less serious physical injuries, and light or grave coercion, ignominy. And murder, of course. No? In one case, sabi ng Supreme Court, there is ignominy when in compelling the old woman to confess to the theft of clothes. The accused maltreated her and took off her drawers. No? The purpose is to put her to shame. A lawful entry to effect entrance and not for escape. By means of motor vehicle, number 20, motor vehicle was used in facilitating the escape. It should not be an aggravating circumstance. What is cruelty? Cruelty, physical pain. When cruelty enjoys and delights in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the commission of the act. So cruelty, there's physical pain. Ignominy, there's emotional, or the purpose is to humiliate the victim. Be deliberately abetted by causing other wrong. This phrase means that the accused at the time of the commission of the crime had a deliberate intention to prolong the suffering of the victim. Okay. Relationship is taken into account when the offended party is the spouse, ascendants, descendants. Yeah. Alternative circumstances may be taken as aggravating or mitigating according to the nature and effects of the crime. Other conditions. So there are RIDE, relationship, intoxication, degree of instruction, and communication. Relationship of stepfather or stepmother, stepson, stepdaughter included by analogy here. Relationship is mitigating in crimes against property by analogy, but in theft, estafa, and malicious mischief, relationship is exempting. Relationship is aggravating in crimes against persons if the offended party is a relative of higher degree, or when the offender and the offended party are relatives of the same degree. But if the relationship is an element of the crime, katulad ng parricide, do not appreciate this. It's neither aggravating or mitigating. In crimes against chastity, always aggravating, regardless of higher or lower degree. Okay, what else? Intoxication. Intoxication is mitigating if not habitual or not subsequent to the plan to commit a felony. Aggravating if intoxication is habitual and subsequent or intentional, subsequent to the commission of the crime. Degree of, well, ang tatandaan nyo lang, it is intentional when the offender, even if it's not habitual, pero intoxication is used to embolden him to commit the crime, then this is appreciated. Degree of instruction and education, law of degree of instruction and education, or lack of it is generally mitigating. High degree of instruction, education is aggravating when the offender avails himself of learning. Lack of sufficient intelligence is required in illiteracy. Ibig sabihin, illiteracy alone is not cannot be appreciated, but it should also be because of lack of sufficient intelligence, to invoke the this alternative circumstance of lack of instruction. So it's not mitigating in crimes against property. So kung illiterate ka, grade 1 ka, grade 2, no, not mitigating. Not mitigating also in crimes against chastity. No one is so ignorant as not to know that the crime of rape is wrong and in violation of the law. Lack of education and instruction is not mitigating in the crime of murder. Degree of instruction is aggravating when the offender availed himself or took advantage of it in committing the crime. Okay, let's have a break. Next After the break, we will be discussing the indeterminate sentence law and we'll go into book 2. Let's have a 5-minute break. Okay, can we proceed now? Okay. So we will go now to the indeterminate sentence law. Anong dapat tandaan lang sa Islaw? Islaw, the law mandates that to impose the maximum and minimum term of the indeterminate sentence. No? Mandated ang bawat court to impose the maximum term and minimum term of the indeterminate sentence. What you have to remember, if this will be asked in the bar, dalawa lang yan. It's either on the disqualifications and the computation. So you'll have to memorize the disqualification under the indeterminate sentence law and know the formula on how to secure the minimum term and the maximum term of the indeterminate sentence. So, unang-una, ito, let me share. Here. Ano muna yung purposes of indeterminate sentence? Lumabas minsan sa bar yan. Well, to uplift and redeem valuable human and material, prevent unnecessary excessive jurisdiction of personal liberty and economic usefulness. It is intended to favor the accused, particularly to shorten his term of imprisonment depending upon his behavior and physical, mental, moral record as prisoner. Okay, if a special penal law, question, adopts the penalties under the RPC, will the indeterminate sentence apply just as it would in felonies? Yes, like as I've mentioned before, RA 7610, which is child abuse, is a special penal law, yet it adopts the nomenclature of penalties of the RPC. So therefore, in determining the maximum term and minimum term of the indeterminate sentence, you will have to use the formula for the RPC and not that of the SPL. So, magkakaroon ka din ng rule of offsetting, of mitigating and aggravating because you use the formula of the RPC, although child abuse is a special penal law. These are the things that you have to memorize. Punished by death or life imprisonment or reclusion perpetua. Do not interchange the disqualifications under probation law from that of Islaw. In probation law, if the penalty exceeds 6 years, ito hindi. Offenses punishable by death or life imprisonment or reclusion perpetua by analogy. No? So yung death and reclusion perpetua, if it's an RPC, indivisible penalties. So this will not be applied, Islam will not apply to indivisible penalties. Or those convicted of treason, conspiracy to proposal to commit treason. Treason, ano bang treason? There is a breach of allegiance by a person who owes an allegiance to the state by levying war or adherence to the enemy, giving them aid and comfort. Conspiracy and conspiracy to commit treason. When 2 or more persons come to an agreement concerning the commission of a treason and they decide to commit treason. Proposal. When a person who decided to commit treason proposes it to another. Misprision of treason. When a person has knowledge of conspiracy to commit treason and he fails to disclose it to the proper authority. Rebellion. There's a rebellion. The purpose is to overthrow the government. There is a public uprising and taking arms against the government. Sedition. There is a public or tumultuous uprising. No? It's political. It could also be social. While in rebellion, it's purely political. Espionage, di ba? In times of peace and in times of war, espionage is it's like a James Bond. He went to the naval, military establishment in order to secure confidential information. Or if it's a public official and they disclose it to a representative of another or of a foreign country. Those convicted of piracy, there's intent to gain. It's like robbery, but only in high seas or in Philippine waters. Seizing the vessel or its belonging. Habitual delinquents, if within a period of 10 years, reckon from where? Last release or he commits the crime of serious physical injuries, robbery, theft, estafa, falsification. How many times? A third time or offender. Within 10 years from his last release or last conviction. And 6, those who escape from confinement or those who evaded sentence. 7, those granted with conditional pardon and he violated the same. And 8, those whose maximum period of imprisonment should not exceed 1 year. Or those already serving final judgment upon approval of this act. Memorize all of this. Kasi if the disqualification is present, you don't have to compute. If there is rebellion, then you don't even have to compute. If there is piracy, don't compute. If you escape from prison or evaded the sentence, don't ever compute. And do not, probation is not included, but do not apply the disqualifications of probation here. When a person has already filed an appeal, no, that's not a disqualification here. Or if he committed the crime of against national security, do not, forget about probation. It's not included. Okay, so let's go down specifically on how to compute. As I've said, the first disqualification is that if the penalty is reclusion perpetua or death. So kung nakita niyo yung reclusion perpetua or death, wag niyo nang compute because it has its own formula, no? If it's a single, indivisible penalty, and 2 indivisible penalty. Pag sinabing 2 indivisible penalties, it does not have any periods. It does not have medium, minimum, or maximum periods. So if you have reclusion perpetua or death, reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto menor. Okay? If the penalty is death or reclusion perpetua, these are indivisible penalties. So do not apply this one. Sabi kanina, if the maximum penalty does not exceed 1 year, Arresto Mayor carries the penalty of 1 year, 1 day to 30 days. Arresto Mayor, 1 month, 1 day to 6 months. Prison Correctional, 6 months, 1 day to 6 years. Prison Mayor, 6 years, 1 day to 12 years. Reclusion Temporal, 12 years, 1 day to 20 years. Reclusion Perpetua, 20 years, 1 day to 40 years. Okay? So since this is in the express prohibition, death or reclusion perpetua, so X na to. This is not included anymore. Also, the law provides that if the maximum penalty does not exceed 1 year, so if it's arresto menor, which is 1 day to 30 days, not also applicable. If 1 month and 1 day to 6 months, arresto mayor is also not applicable. Ergo, islaw is only applicable if the penalty is in these three: prison mayor, prison correctional, prison mayor, and reclusion temporal. These two is included in the first disqualification, and this one is included into the last disqualification. If the penalty is reclusion perpetua, and then the law provides, halimbawa, in the example, in the bar exam, there is voluntary surrender. There is plea of guilt. No, these are mitigating circumstances. Will you appreciate this one? No, because it's reclusion perpetua, and reclusion perpetua is a disqualification under Islaw. No? Voluntary surrender is an ordinary mitigating. Plea of guilt is an ordinary mitigating. Now, it will be different if there is a privilege mitigating. If, say for example, 16 years of age acting with discernment, you lower this with 1 degree. Alam naman natin, if it's a privilege mitigating, the first thing that you do is to go down. So reclusion perpetua, you go down to reclusion temporal. The question is reclusion temporal divisible or divisible? And it's included under Islaw. So you will apply this. Divisible. Now you appreciate voluntary surrender and plea of guilt. But if there's no privilege mitigating, if it's just an ordinary mitigating, generic aggravating, no appreciation. Kahit damihan mo pa siya ng immediate vindication, passion and obfuscation, lack of intent to commit so grave a wrong, it has no bearing because it's reclusion perpetua. Okay, 2 indivisible penalties. If the penalty is reclusion perpetua to death, but these are indivisible penalties, so Islaw is not applicable. You only choose which one is the higher, the greater, and the lesser. If there is 0 mitigating and 0 mitigating, 0 aggravating, you only have to choose which one, the higher, the lesser, death or reclusion perpetua. If 0-0, it's the lesser penalty, which is reclusion perpetua. If it is 1 mitigating, 0 aggravating, it's the lesser penalty. If 0 aggravating and 1 aggravating, it's the higher penalty. It has its own rules. I'm only showing you that they have the own rule and do not apply Islaw. No, in these cases, pag nakita mo ng mga indivisible penalties, Don't ever compute, no, because it will not be appreciated anymore. Next. So this applies to a mitigating to a divisible penalty. A divisible penalty which has the minimum, medium, and maximum period. Okay, let's go. As I've said, this is both applicable to SPL and FTC and RPC. SPL muna tayo. How do you get the maximum term? Do not say minimum sentence. Do not say minimum penalty. That is wrong. To get the full credit, you say maximum term and minimum term of the indeterminate sentence. Maximum term, minimum term of the indeterminate sentence. Again, since this is an SPL, there is no appreciation of mitigating and generic aggravating circumstances. So simple lang yan eh. When this is asked in the bar, no, the bar exam would show two things. No, the penalty provided for by law. Second is the penalty imposed by the court. Ang tanong dyan, is the penalty thus imposed by the court correct or not? Assuming, example, for illegal possession of firearms, the penalty is 5 years to 10 years. So the maximum is penalty under the law, no, is 10 years and 5 years. Ano bang, what is the law? What is the rule insofar as obtaining the maximum term and minimum term? The law provides that if it's an SPL, the maximum should not increase, should not be greater or should not exceed the maximum penalty or sentence fixed by law. It should not exceed the maximum penalty or sentence fixed by law. Insofar as the minimum term is concerned, how do you obtain it? Well, for as long as it's not lower than the minimum term fixed by law. So anywhere in between would be proper. So the court has the discretion to impose for as long as it should not exceed the maximum penalty or sentence fixed by law, fixed by the SPL, and it should not be lower than the minimum penalty fixed by the special law. So, for example, if there's illegal possession of firearms, the penalty is 5 years to 10 years. What the court actually imposed, the penalty of 6 years to 9 years. Is the penalty thus imposed by the court correct, proper or not? So it's 9, it's 6 to 9 years. So the question is it lower than the 5-year minimum fixed by law? It's not. It's within, right? What about the maximum? Does it exceed the maximum penalty fixed by law, which is 10 years? No, it's 9. So it's been in between 5 to 10. No problem. That's proper. Next, the court imposed a penalty of 5 years to 7 years. 5 years to 7 years. Of course, obviously, it does not exceed the 10-year period fixed by law. Now, the question, is it lower than the penalty fixed by law, which is 5? 5 to 5? No, di ba? So it's also proper. Check. The penalty imposed by the court is 5 years to 12 years. 5 years to 12. Is it lower than 5 years? No. So minimum term is proper. What about the maximum term imposed by the court? 12 years, where the law fixed is only 10 years. So 12 as to 10, it exceeded 10 years. So in this case, it's not proper because the maximum term fixed by the court exceeds the 10-year penalty fixed by the special penal law. So madali lang SPL. Anywhere in between is proper. Okay? I hope you get it. Okay, matatakot sa SPL, sa Islaw, madali lang yan. Oh, let's go to the revised penal code. RPC. How do you get the maximum term and the minimum fixed by minimum term and the maximum term? This is the rule. We follow the rule on divisible penalty. Sabi niya, in view of the attending circumstances. Meaning to say, you will have to apply the rule of offsetting. Meaning to say, to get the maximum term, you would appreciate the presence of the mitigating and the aggravating circumstances present. Ordinary mitigating and generic aggravating. So this is the only instance where we appreciate the presence of the mitigating and aggravating. So how do you get the minimum term? You get the minimum term by it's 1 degree lower than that imposed by the RPC, 1 degree lower than that imposed by the code or the RPC, and don't forget this, the period. The period is only cut and paste. It's the same formula. This is how you will state it. The period of which is upon the discretion of the court. This one, no, is always constant. If it's the minimum term, the period in the minimum term, you say the period of which is upon the discretion of the court. Sabi sa court, sabi sa ano yan, sa Islaw is the range of the penalty. Ito na lang yan mas madali itong i-apply. Okay. Let's go to the rule of offsetting. We just apply the rule obtained in the divisible penalty. You have the mitigating and the aggravating circumstances. So, if you have zero mitigate, when I say mitigating, I am referring to generic aggravating. When I talk about aggravating, I'm talking about generic aggravating as opposed to that of ordinary mitigating. If it's 0, 0, so divisible, you have minimum, right? Medium and maximum period. Mawa. Sample lang example. reclusion, prison mayor. Prison mayor, 6 months, 1 day to 6 years. Okay? 6 months, 1 day to 6 years. You know that. You memorize that. Prison correctional. Okay? You divide it equally into 3. You will have the minimum term. You will have the medium, as well as the maximum term of the indeterminate sentence. So prison correction, we're talking about the period. No? Period. When you talk about the rule of offsetting, we're talking about the period. When you talk about privilege mitigating, we're talking about degree. No? Degree. So if there's mitigating circumstance, 0 mitigating and 0 aggravating, you will arrive at what? Medium. Let's just erase this one. The medium period, 0, 0. 1 aggravating, 0 mitigating, you will have the minimum. 0 mitigating, 1 aggravating, you will have the maximum period. 4th, 1 or more, 2 or more, I'm sorry. 2 or more mitigating circumstances as against 0, you will have 1 degree lower. Remember this one. If there are, and this is only applicable to divisible penalties, if there are 2 or more mitigating circumstances and 0 aggravating, you will not reduce it by in its minimum period, but you reduce it by 1 degree lower. Now, question, is this a privilege mitigating? No, it's not. Why? Because it can be offset by any ordinary mitigating, no? But it is only akin to a privilege mitigating in the sense that you will reduce it not in its minimum period, but by a degree. But this is not a privilege mitigating. So if this is applied in an indivisible penalty, ang daming mitigating circumstances, pero ang penalty is reclusion perpetua, bababa ka ba ng 1 degree? No, because this is applicable only to a divisible penalty. In indivisible penalty, as I've mentioned, do not apply any ordinary mitigating and generic aggravating as in this case, because this is not a privileged one. Number 5. Oh, sir, paano kung there are 5 mitigating as against 1? In the rule of offsetting, sir, do we reduce it by 1 degree or only in its minimum period? No, you will only reduce it to minimum period. Sir, why? Because there is 1. You only reduce it by 1 degree lower when the aggravating is 0. Next. Now, sir, if there is a no mitigating and there are 2 or more aggravating, does it mean that we will increase it by 1 degree? No, because this is not favorable to the accused. So what you do is only to impose it to its maximum period. Now you apply the rule. 7, 0, 2 mitigating as against 2 aggravating, offset it, you will have arrived at the medium period. Next, assuming that there is 1 mitigating, 3 aggravating, and you offset this, you will arrive at the maximum period. That's it. That's it. This is how to obtain the maximum term of the indeterminate sentence. No, you apply the rule of setting, appreciate the mitigating and generic aggravating, and the minimum term would be 1 degree lower, no, and the period of which is upon the discretion of the court. Sir, why must we secure the maximum term and minimum term of the indeterminate sentence? Ano bang purpose niyan? Because once the convict had served the minimum term of the indeterminate sentence, no, he will now be eligible to be released on parole. Okay, laya na siya. Only has to report to the parole officer. But why must the court impose the maximum term? Just in case the convict, when talking about the convict, no, kasi ang convict kailangan mag-serve muna ng minimum term in order to be released. But if he violates the condition of his parole, then he will have to serve the maximum term of his indeterminate sentence. Okay? So, let's have an example now. Assuming that the penalty is reclusion temporal and you have voluntary surrender present. Let's go to basic. The penalty for a particular crime is reclusion temporal. And what is present is voluntary surrender. The question is, determine the maximum term and the minimum term of the indeterminate sentence. Okay, reclusion temporal, you have voluntary surrender is what kind of circumstance? It is an ordinary mitigating. Is there ordinary mitigating, one ordinary mitigating? Do you have any aggravating circumstance? Zero. So you will have a case where there is one mitigating and zero aggravating, then you will have to impose the minimum, right? So the answer is this. No, reclusion temporal in its minimum period as what? As the maximum term of the indeterminate sentence. So that's the way to answer it. It's reclusion temporal in its minimum period as the maximum term of the indeterminate sentence. What is the minimum term? What's 1 degree lower than reclusion temporal? It's prisión mayor, right? Prisión mayor, what is the period? Cut and paste. This is what you will write. Prisión mayor, the period of which is upon the discretion of the court as what? As the minimum term of the indeterminate sentence. That's how simple Islao is. Okay. Let's have an example. Another example. The penalty is prisión mayor. You will have passion and obfuscation. And you have 17 years of age acting with discernment. Okay? Now, you have determined the maximum term and the minimum term of the indeterminate sentence. Passion and obfuscation. What the first thing that you do is to determine what are the circumstances present. What is its classification? So 17 years of age, acting with discernment is a privilege mitigating. And passion and obfuscation is just an ordinary mitigating. and there's no aggravating. So what must you do? If you see a privilege mitigating, what you do is to appreciate first a privilege mitigating, such as this one. Lower it automatically. So you will arrive at prison correctional. No? Prison correctional. And what is the period? Now you have 1 mitigating as against 0 aggravating. You will have prison correctional in its, since there's 1 mitigating and in its minimum period as the maximum term of the indeterminate sentence. Now, if there's a privilege mitigating, the point of reckoning is now the privilege mitigating. Here, no, the penalty that you arrive at. So it's the minimum term now is arresto mayor. Okay, that's 1 degree lower. That's arresto mayor, the period of which is upon the discretion of the court. Okay, that's the second example. Assuming that you have prison, reclusion temporal, you have aid of armed men, okay, and what? You have voluntary surrender, and you have 17 years of age with discernment, determine the maximum term and the minimum term of the indeterminate sentence. Okay, 17 years of age is privilege mitigating. Armament is an one aggravating. Voluntary surrender is 1 ordinary mitigating. Offset 1 aggravating and 1 mitigating, you will arrive at medium period, right? Yeah. So since there's a privilege mitigating, appreciate first the privilege mitigating. So from reclusion temporal, you go down to 1 degree is prison mayor. And then 1 as against 1, then you will arrive at the medium. So the maximum term is prison mayor in its medium period as the maximum term of the indeterminate sentence. 1 degree lower is prison correctional. And cut and paste, the period of which is upon the discretion of the court. Dali lang siya, right? I hope you get it. The person is convicted of the penalty is prison mayor. You have immediate vindication. You have plea of guilt. Determine the maximum and the minimum term. And he is convicted of the crime of rebellion. You know that these are 2 mitigating circumstances, but do you have to compute? No, you don't have to compute because the penalty is rebellion. And rebellion is what? A disqualification under law. So no more of this. No? Now, the penalty is 1 month, 1 day to 6 months. Is this correct or not? No, because the penalty is 1 year or less. if the penalty is 1 year or less, ang sabi ng batas, impose a straight penalty. Meaning to say, don't even have to state minimum term and maximum. The court can impose 6 months or 7 months and 1 day. Don't indicate the maximum or minimum term because the penalty is 1 year or less. But say, for example, you were asked in the bar, the penalty is 6 years. Penalty is 3 years and 1 day for possession of illicit drugs. Is the penalty imposed? Correct or not? No, because this is an SPL and it's more than 1 year. Then the court is mandated to get the maximum to impose a maximum term and the minimum term of the indeterminate sentence. Okay? If the penalty, halimbawa, this were asked in the bar. The penalty for murder, assume, is reclusion temporal. He is convicted of frustrated murder. And you have unlawful aggression, and you have reasonable necessity of the means employed to prevent or repel the same. Okay, determine the maximum term and the minimum term of the indeterminate sentence. That's the trick in the bar. Frustrated murder and frustrated murder, you know that there's 1 degree lower yan, di ba? 1 degree lower. You know that if it's consummated, frustrated, attempted, frustrated, it's 1 degree lower than that imposed upon a consummated stage. If it's attempted, frustrated, 1 degree lower than that of consummated. Attempted is 2 degrees lower. So pag sinabing frustrated yan, so sa consummated murder is reclusion temporal, you will impose the 1 degree lower, which is prisión mayor. But you have unlawful aggression and reasonable necessity. This is incomplete self-defense and the majority are present. So the penalty again is 1 degree lower, reclusion, prison correctional, right? Is there any aggravating or mitigating circumstances? No. So what will be the penalty? The penalty is prison correctional in its medium period as the maximum term of the indeterminate sentence. Okay, 1 degree lower is minimum is arresto mayor, that's 1 degree lower. And the period of which is upon the discretion of the court. Okay? Ayan. So by last one. Reclusion, prison mayor, you have 17 years of age with discernment. You have unlawful aggression. You have lack of sufficient provocation. And you have voluntary surrender. Determine, this is my last so far as Islaw, and the minimum term of the indeterminate sentence. 17 years of age acting with discernment is what? Privilege mitigating. Unlawful aggression, lack of sufficient provocation is privilege mitigating. Voluntary surrender is ordinary mitigating. So what you do now is appreciate the presence of the privilege mitigating circumstances. So since it's prisión mayor, 1 degree lower than prisión mayor is Prison correctional. Then you appreciate another privilege mitigating, this one. You will go down to arresto mayor. You have one ordinary mitigating, so arresto mayor, and zero aggravating in its minimum period. So supposedly the maximum term is arresto mayor in its minimum period, and the minimum term is arresto menor. No, the period of which is upon the discretion of the court. No, but since arresto mayor carries the penalty of what? Is it less than one year? Yes, it's only 1 month, 1 day to 6 months. It's less than 1 year. So you will conclude that this law is not applicable in this case. But you will have to show your computation. Whenever, no, when you arrive at the your answer, you show how you arrive at a particular answer. So you explain what are the circumstances that you appreciated, whether it's a privilege, mitigating, or just an ordinary or a generic aggravating circumstances. Okay? Yon. So we finish with Islaw. So we go with the last topic in book 1. Which is the extinction of criminal liability. O wala extinction. No. I missed the extinction of criminal liability. Well, anyway, the law provides that service of sentence is a total extinction of criminal liability. What is the effect of death? Death before or after final conviction, no problem with that. So there's no criminal liability, no? Insofar as pecuniary liability, no? Pecuniary liability is extinguished if there is no final conviction. No, it is not. If death occurs before final conviction. If death occurs after final conviction, then pecuniary liability is not extinguished. So, bawa, he was convicted of murder, no? And he appealed this case to the Court of Appeals. No? Pending review by the CA, it's not yet final. No, because there's still an appeal. If he dies while the CA or the Court of Appeals is reviewing the case, then his pecuniary liability is extinguished. But say, for example, the CA already affirmed the decision of the RTC, and there was no appeal to the Supreme Court, and there was already an entry of judgment, no? And the records are now remanded to the MTC, to the RTC, to the Court ACO, and there's already an entry of the judgment. Is it final or not? It's already final because there's already an entry of judgment. And after the entry of judgment, no, the appellant died. Okay, will it extinguish his pecuniary liability, civil liability? No, because he died, no, after final conviction. Now, it will extinguish his pecuniary liabilities where he dies before final conviction or final judgment, no, is only applicable to crimes arising from, to civil liability, pecuniary liabilities arising from delict. Now, if the civil liability arises from a contract, an obligation, and this is not applicable, that's another also another situation, no? Hindi siya applicable. So magiging liable siya because it arises not from delict but from other obligation. So what is being referred to is an obligation arising only from a crime. Okay. We finish with book 1. I hope that we can finish with the others. Okay. Let's go to book 2. Book 2, let's go to falsification, forgery. When you talk about forgery under 169, it only refers to treasury, banknotes, or instruments payable to bearer, the appearance of a true and genuine document. ESCA, the second is erasing, substituting, counterfeiting, or altering letters, figures, or words contained therein. So how do you differentiate forgery from falsification? Forgery under 169 is limited to TBI, treasury, banknotes, instruments to be payable to bearer or to order. Now, kinds of documents, public document, notarized yan, official document, issued yan ng government or its agents, no? Private document, deed executed ng private individual without intervention ng notary public, commercial document executed in accordance with the Code of Commerce, no? Or our mercantile law. Several cases insofar as falsification, counterfeiting, imitating any handwriting or signature, no? Or causing it to appear that the person have participated in any act or proceeding where in fact they did not so participate. It is not necessary that the imitation be perfect. It is enough that there should be an attempt to imitate of two signatures, the genuine and the forged. They bear resemblance to each other. Making untruthful statement in a narration of facts. Elements, merong obligation on the part of the accused to disclose the truth. And second, wrongful intent to injure a third person. The untruthful narration must also be such as to affect the integrity of the document or change its effects, no? Change the effects which it would otherwise produce. When you talk about legal obligation, it means that there is a law requiring the disclosure of the facts contained in a document. It is if in the deed of sale of a parcel of land, the accused made it appear that the property is free from all encumbrances, where in truth and in fact he did not own the land, the crime committed is estafa through falsification of a public document. Pag sinabing altering of true dates, dapat yung the true date is essential. It has no application, the rule has no application when the act is committed not by ignorance or mistake, but rather to prevent the discovery of an illegal appropriation of public funds. Now, making alteration or intercalation in a genuine document. So there is a genuine document, there is an alteration or intercalation, something is inserted therein, which changes the meaning of the document, and the change made the document speak something which is false. So an alteration which makes a document speaks the truth does not contain falsification. Dapat it will speak something false. kung nagkaroon ng alteration or intercalation and which makes the document speaks the truth, it does not constitute falsification. Falsification, how do you differentiate falsification of a private document from a public document? Ang falsification, pareho silang merong falsification. What is falsified is a public document. The other one is falsified is a private document. Pero in addition sa private document, there is damage or intent to cause damage. In falsification of a public document, damage is not an element. So once na-falsify mo ang public document, the crime is consummated. So private, once na-falsify mo ang private document, it does not mean that there is already a consummated crime of falsification of a private document. Bakit? Kinakailangan you still have to prove the element of damage. Damage is an element or intent to cause damage. So the falsification is committed in ways specified under 171, no? So that's the difference between the two. So there's also the use of falsified document. No, hindi siya nag-falsified, but the offender knew that the document was falsified by another. The false document is embraced under 171, no? And he introduced such document in evidence in any judicial proceeding. Pag sinabing false testimony against the defendant, false testimony, criminal proceeding. May criminal proceeding yan. So, offender testifies under oath against the defendant who gives the false testimony. Offender who gives false testimony knows na dapat alam niya it is false. The defendant against whom the false testimony is given is either acquitted or convicted in a final judgment. No? So there's also a crime of false testimony in civil cases. Perjury. Perjury. This is a favorite by question. No? How is this committed? This is committed by falsely testifying under oath or making false affidavit. Falsely testifying under oath. So pwede siyang ilagay sa stand, so witness stand, but not in a judicial proceeding. Basta non-judicial proceeding, perjury yun. Or making a false statement. No? Now, requisites na make a statement, okay? Tapos, the statement or affidavit was made before a competent court or a competent officer authorized naman to receive and administer the same. Thirdly, there must be a deliberate and willful assertion of falsehood, okay? And it is authorized by law. And tapos, ang pinaka-importante sa perjury is that it should be on a material matter. Pagka hindi siya on a material matter, wala nang tayong pag-uusapang perjury. It means that the main fact which is the subject of inquiry or any fact or circumstance which tend to corroborate or strengthen the testimony. Okay? So, kung if admitted ba yan, it would probably alter the result of the trial. If yes, then there's perjury. No? Pag sinabing when the law so requires, it does not mean that the sworn statement or affidavit must be required by law. It is only permissive, not mandatory. So in cases in which the law authorizes, yun ang ibig sabihin niya. So sa bar question, sa bar problem, sinabi, isang government employee, i-charge siya ng immorality, having a marriage siya, no, having affair with another co-employee, no? Naniniwala the girl knows that he is single, but in truth and in fact he is married. No, now he was required to submit an affidavit, a counter affidavit, why he was made to explain why he should not be terminated. No, Now, he stated in his affidavit that I, blank, 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 single, and under oath, okay, say the following: I vehemently deny all the material allegations, blah, blah. But he's married, but what he stated is that he's single. And because of that, he was charged with perjury. Is he guilty of perjury? He's not guilty of perjury, because even if there's a willful falsehood asserted by him, it's not on a material matter. No, whether A is single or married, the charge of immorality against him could prosper or proceed. No, so a civil status is not a defense to the charge of immorality. No, so it will not. It will not alter the outcome of the case. So it's not on a material matter. So no perjury. Pero kung siya ay nag-petition siya for naturalization, he's a foreigner, no, and has a petition for naturalization, and he was convicted of a crime, no, of BP 22, which is a crime involving moral turpitude. And he failed to disclose that in his petition. No. Did he commit the crime of perjury? Yes, because it is on a material matter. Because if he's convicted of and it came to the knowledge of the court, then his petition will be denied. But if he's not charged, then his petition may be granted. No? So there's also an offering of false testimony. The offender in evidence, offender offered in evidence a false witness. He knew that that witness is false, that the offers was made in a judicial or official proceeding. So crimes against persons. No, let's discuss. So you have parricide, you have infanticide, you have abortion, excuse me, intentional or unintentional. And you have murder, and you have homicide. Parricide. The killing of the father, mother, or child, whether the relationship is legit or illegitimate. Other ascendants would be, the relationship must be legit. Other descendants, relationship must be legitimate. So, yung grandfather must be a legitimate one. Grandchildren should be legitimate. But if it is father, mother, child, then relationship can be legitimate or illegitimate. So there's no parricide of a brother or sister because it refers only to a direct line, di ba? Direct line lang siya, whether ascendants, descending or ascending. The only one which is that of that relation is the spouse. The spouse which must be legitimate. Okay? Now let's go to infanticide, the killing of a child who is less than 3 days old. So regardless of there's a relationship or not, basta ang edad niya is less than 3 days old, so infanticide. Abortion can be intentional or unintentional. There's intent to abort. And of course, force is also an element of this crime. So if the husband, they had an altercation with the wife wife fell down and died instantly, but she's 6 months pregnant, and the child lived for 20 hours. What crime did H commit? Wife died, so no problem. So there's parricide. It could be a complex crime resulting to what? Parricide, okay? The child lived for 6 months, for 20 hours. Reckon from the time that he was separated from the mother's womb. So is that infanticide or abortion? The law provides that if a child had an intrauterine life of less than 7 months, he should live for 24 hours from the time that he was separated from the mother's womb. So since here he lived only for 20 hours, and kasi 6 months lang siya, so therefore the crime is a complex crime of parricide with unintentional abortion. If the child lived for 8 months, no need to determine whether he lived for 24 hours or not, because 8 months naman siya. Na-satisfy niya yun na yung 7 months. No? Let's go to murder and homicide. Killing which is not infanticide or parricide. In both instances, there's intent to kill. But here we have the presence of qualifying aggravating circumstances enumerated under Article 248. Ang pinaka-importante sa bar yan is evident premeditation and treachery. As I mentioned, dapat pag treachery yan, he had opportunity to defend himself, no opportunity to defend himself, and that it was consciously and deliberately adopted. So it's qualifying in the crime of murder. Evident premeditation is the time that he actually decided to commit the crime, that there's acts manifestly showing that he clung to his determination to commit the crime, and lapse of time from the time he executed to the time that he determined the crime to the time that he actually executed the crime. Yun. No? It's under Article 14, but what is not included in Article 14 is outraging or scoffing at the corpse. This is a qualifying aggravating in the crime of murder. Anong significance? Si A, they had an altercation, no? And B had an opportunity to defend himself. They had a fist fight. But unfortunately, no, nabugbog ni A si B, B died. But there was no treachery. No, he was able to defend himself, but he was overpowered by A. Now, after killing B, what A did is to behead B and threw his head in the river. What crime did A commit? The crime A committed is outraging or scoffing at the corpse. It is immaterial already whether B was able to defend himself or not. Now, remove all this qualifying aggravating, the crime is homicide. No, if there's treachery, it's murder. If no treachery, for as long as there's intent to kill, then there is homicide. Okay. I think we need to extend for a few minutes lang. Death under exceptional circumstances, you know this already. That is a legally married person that he surprised his spouse in the act of committing intercourse, that he killed this person either during the act of committing the sexual intercourse or immediately thereafter. So, yun. What else? We also death in a tumultuous affray. If a person dies and the one who inflicted somebody was killed, no, and the person who killed this person cannot be identified, no, but the one who inflicted serious physical injuries or used violence can be identified. So yun ang elements. But the groups, though, there should be several persons, and these do not compose of groups organized for the common purpose of assaulting or attacking each other. So hindi pwedeng silang fraternity, naghamunan sila mag-away, mag-grumble. No. This group should not be for the purpose of assaulting and attacking each other. So I think let's go to crime against property. Let's go to crime against property. Robbery. Theft. And estafa. Robbery, there is intent to gain. There is unlawful taking of personal property that belongs to another, and that there's violence, intimidation against a person, and there is force upon things. Yeah. Intent to gain. Pareho rin sila ng element ng theft. Unlawful taking, meron din. Personal property, meron din. It belongs to another, yes. Except that there's no violence or intimidation against persons or force upon things. No? And there's robbery. Robbery, theft, we also have other ways to commit theft. No? Finder's keeper is also theft. The only difference between theft and estafa, no? When you have physical possession, you have theft, qualified theft, usually. No? Estafa, there is a juridical possession. You can even set it up against the owner himself. No? Halimbawa, nagpagawa ka ng sasakyan sa repair shop, ang kontrata nyo is 5 days. So yung 5 days na yun, yung repair shop has juridical possession over the same. Pero kung may driver ka, in driver mo, binigay mo lang ang susi, no? And he's doing his job, that's only physical possession, and that's that estafa. Okay, let's go to our special complex crime. Robbery, excuse me, with homicide. It's a special complex crime. Homicide in this case is used in a generic sense. So, this is a special complex crime where two crimes are committed but punished under a single provision of the RPC. Sabi ng batas is if by reason or on occasion of robbery, somebody dies, then the crime is robbery with rape, robbery with homicide, even if the killing is not intentional. So generic, this is intentional or unintentional. Okay. Is there a crime of robbery with murder? Wala, because no, it's already included in the crime of robbery with homicide. So what does it mean? This is applicable actually if at the onset there is intent to gain or intent to rob, and somebody dies before, during, or immediately after the robbery. No? Yun. So, somebody dies. Even if the killing is not part of the plan. Say, for example, A and B and C decided to rob X in his house. So they have a plan. Ikaw, si A and B were to go inside, amass all personal properties. Si C, nakita si X, he was sleeping, and he doesn't want to be identified by C, killed X. And they were able to escape, all of them. They were charged with robbery with homicide. Are they liable for robbery with homicide? A and B as well? Sabi ni A, I'm not liable for robbery with homicide because I'm only liable for the crime that we conspired to commit, which is only robbery. C alone should be liable in this case. Is the contention of A tenable or not? The answer is no, because this is a special complex crime of robbery with homicide. If by reason or on occasion of robbery somebody dies, then all of them will be liable for robbery with homicide, even if the killing is not part of the plan. Okay. Say, for example, C was not intentionally killed, but he fell down from the stairs and C died, while A, B, C, and are in the act of escaping. Would they be liable for the death of C? Yes, because again, he died by reason or occasion of robbery, even if he died immediately after the robbery and he died unintentionally. It's still robbery with homicide. Okay? What if A was in the second floor, a co-conspirator, and A was the one who fell from the stairs and died? B and C were charged with robbery with homicide. Sabi nilang dalawa, hindi kami liable because no, they are our companions and principal. Is the contention correct or not? No, because again, if by reason of or occasion of robbery somebody dies, then they will all be liable, even if the person who died is their co-conspirator. Yeah? So, ganun yun. What if what they plan is actually only to commit the crime of murder, and robbery is an afterthought. A, B, and C conspired to kill X. So they went inside the house and killed X. Thereafter, C saw the jewelry box of X and forcibly opened the same. Okay, are they liable for robbery with homicide? No, because at the onset, ang requirement ng batas, there should be intent to gain. At the onset, what was their intent? Intent is to kill. And in this case, what will be the crimes committed? A, B, and C will be liable for the crime that they conspired to commit, which is murder. C, in addition, would be liable for robbery. No? But C alone should be liable for that because no, wala namang kinalaman si A and B unless they become an accessory in this case. Now, robbery with rape. Ganoon din. If by reason on occasion of robbery somebody was raped, then all of them will be liable for composite crime of robbery with rape, even if rape is not planned. What will be the proper defense of A and B? So, if they endeavor to prevent C from raping X. Sir, paano kung namatay at na-rape? They will be liable for robbery with homicide. Rape will be considered as what? As an aggravating circumstance. Okay? Next. Robbery with force upon things. If the breaking of the roof, no, the wall, the floor, the windows, and the door. Why must the offender break the wall, roof, door, floor? The purpose is to effect entrance. That's robbery with force upon things. O kaya using false keys. Okay, to effect entrance. O kaya is simulation of authority to effect entrance. O kaya without breaking, without these circumstances, open lang ang door, pumasok siya without all these three instances. But the offender took or inside, no, had forcibly opened or have broken any closed receptacle or furniture, they will be liable for robbery. O kaya they took this closed receptacle or furniture to be broken outside, then they will be liable also for robbery with force upon things. Qualified theft if committed by a domestic servant or abuse of there is of course importante dito yung motor vehicle, no? Motor vehicle, okay? How do you differentiate that from carnapping? Pagka-carnapping, it is taking the motor vehicle without the consent of the owner or using force or intimidation. Motor vehicle is that he has physical possession over the same. Ibinigay sa kanya yung susi kasi driver siya, kaya lang hindi niya binalik, di ba? Or coconut taken from plantation, or fish taken ng fish pond to protect their industry, kaya yan ang ginawang krimen ng batas. Or on the occasion of a calamity or vehicular accident, lumabas sa bar to, no? Vehicular accident. Liable sila for qualified theft, no? Finders keeper is also a theft, crime of theft. Let's go to estafa. Estafa is through abuse of confidence or through deceit. But they have a common element. What is the common element? The common element is that there should be damage or intent to cause damage. Common na lumalabas sa bar is through a misappropriation. Appropriation of funds. So, he holds the property by commission, trust, or administration, not in the concept of the owner. Pag owner yan, walang estafa. Bawa, ito yung Avon Products. No? Siya ay agent. Obligation of the agent is to sell it to the public. Once he sold this to the public, then his obligation is to remit. And that's the time that he will receive his commission. If he's unable to sell it, no, bring and return the items. If he failed to remit the same, then he will be liable for estafa through misappropriation. But if he bought these properties, wala siyang obligasyon. Halimbawa, si A bumili siya ng TV, installment, 10 installments, equal installment from SM, worth 50,000 pesos. Okay? On the first month, nakabayad siya. On the second month, di na siya nagbayad. Binenta niya sa cousin niya, worth, tumubo pa siya tumubo, 55,000. And he failed to pay SM. Question, will he be liable for estafa? No, because he bought the item on installment. He's in possession thereof, in the concept of an owner. If at all, the liability of A is only civil in nature. Okay? Estafa through post-dated check. Estafa through post-dated check, differentiate this from BP22. Here, there is damage. BP22 through issuance of a post-dated check. BP22, there's damage or intent to cause damage. BP22, none. No? There is payment of simultaneous obligation. Simultaneous with the parting of the goods is the employment of deceit. So sabihin, eto may cheque ako. No, may cheque ako. Give me your goods because I assure you this check is funded. So there's an employment of deceit. Were it not for the deceit, the other party would not have given me the goods. Sa BP22, wala. Pre-existing obligation nito. Meaning to say, that has been our commercial transaction in the past. Give me your goods, I'll pay you in check. Give me your goods, I'll pay you in check. Pero at one point, tumalbog ang cheque. What else? They have dito sa post-dated check, sa estafa, is given only 3 days to make good the check. Otherwise, it will give a presumption of deceit. Sa BP22, wala. 5 days siya. 5 banking days. Otherwise, it will give a presumption of knowledge of insufficiency of funds. Sa estafa, knowledge ng presumption of deceit. A person can be both liable for estafa as well as issuance of a post-dated check as well as for BP22. Of course, estafa is under RPC, BP22 is as SPL, estafa, good faith is a proper defense, BP22, good faith is not a proper defense, right? What is punished in BP22 is what? Issuance of a worthless check. Sa estafa, there's an element of bad faith or deceit. Okay? Yun. Siguro. Will it be possible if we extend for some time just to say, just to I can also include special penal laws. Okay lang ba? Let me go into the best SPL. Okay, let's go to special penal laws. I hope everyone can see this one. Violence against women and children. So this is sabi Abausi, Safe Spaces Act, Child Abuse, and Data Privacy. Those are the topics included in the bar exam. Okay. Define violence against women and children. It refers to any act or series of acts committed by any person against a woman, not against any woman, but the woman must be his former wife or his wife, or against a woman with whom a person has a sexual or dating relationship. O kaya, with whom he has a common child, whether or against the child himself or herself, no? And whether legitimate or illegitimate, within or without a family abode, which result or likely to result into physical, sexual, psychological harm or suffering or economic abuse, no? Including threats of acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. So we have, thank you, ngayon ko lang nabasa sa inyo, yes, our pleasure. So we will extend for a few minutes. When you talk about violence, you got physical, sexual, psychological, and economic abuses. So this question is based on a recent decision. Are acts of violence against women and children deemed as transitory or continuing crimes? What may give, Supreme Court said that what may be gleaned from RA 90, Section 7 of RA 9262 is that the law contemplates that acts of violence against women and children may manifest as transitory or continuing crimes, meaning that some acts, material or essential thereto, and requisite in their consummation occur in one place or territory, while some occur in another. Sabi ng court, pagka gano'n na nangyari, you can file it in any place. A person charged with a continuing or transitory crime may be validly tried in any municipality or territory where the offense was in part committed. Ang TPO, temporary protection order, cannot be issued in favor of a man against his wife. Bakit? Wala pa tayong violence against women, against men and their children. So pinagalitan ng court itong judge na nag-issue nito. What is the concept of a battered women syndrome? It refers to a scientifically defined pattern of psychological and behavioral symptoms found in women but in living in a battering relationship as a result of cumulative abuse. So I think you should memorize this. Don't take the bar without memorizing Section 26. No, lagyan nyo ng star yan. Is a battered women syndrome a proper defense? This has been asked several times. So victim survivors who are found by the courts to be suffering from a battered women syndrome do not incur any criminal or civil liability, notwithstanding the absence of any of the elements of justifying circumstances of self-defense. Meaning to say, kahit walang unlawful aggression, kahit reasonable necessity, kahit wala nun, Kung halimbawa pinatay niya asawa niya, natutulog, no? It can be it will be a proper defense. She will not incur any criminal or civil liability for as long as she can prove that she's suffering from a battered women syndrome. The case of People versus Enosa, remember this. There are 3 phases and 2 cycles. Tension building, acute battering, and also tranquil loving period. No? Say for example, ito, tension building, acute battering, and you have tranquil loving phase. Pag lumabas sa bar, pagka ginulpe kaagad ang wife niya, it doesn't necessarily mean that she's suffering from a battered woman syndrome, because you have to prove, you have to look at whether it underwent these 3 phases. And it should be in 2 cycles. Kung dito lang tumigil yan at hindi na pinakita sa bar, no? So wala yon. It's not. She's not suffering from battered women syndrome. Or if it fails to state that it underwent 2 cycles. When you say tension building, this is where the minor battering occurs. Acute battering is characterized by destructiveness, brutality, or even death. Tranquil loving is where the man would ask forgiveness from his wife, and the wife would forgive him. Knowing that she's the sole anchor of the man's emotional stability, siya lang ang nakakaintindi sa kanyang husband. No? She can justify that. Okay? If that happens in 2 cycles with these 3 phases, then she's suffering from a battered women syndrome. Next. So as I mentioned, tension building, this is where the minor battering occurs. Verbal, slight physical abuse, or other hostile form of behavior. Acute battering, brutality, destructiveness, and death. And as I've said, tranquil loving period is where the couple experience a profound relief. No? On the other hand, the battered woman also tries to convince herself that the battery will never happen again, that her partner will change for the better, and that this good, gentle, and caring man, parang Robin Padilla, is the real person whom she loves. Abuses may be committed by another through conspiracy. So, yung parents-in-law can be also be filed with this case with an allegation of conspiracy. So you know that conspiracy is an idea coming from the revised penal code, but it's applicable here, though this is a special penal law. Does RA 9262 criminalize marital infidelity per se? No, what RA 9262 criminalizes is not the material infidelity per se, but psychological violence causing mental or emotional suffering on the wife. So otherwise stated, said the court, it is the violence inflicted under the said circumstances that the said law seeks to outlaw. Mental or emotional suffering of the victim is an essential and distinct element in the commission of the crime. Coercive control, is it also a form of psychological abuse under RA 9262? Said the court, yes, no, it is. No, coercive control refers to a pattern of behavior meant to dominate a partner. 2 different tactics, katulad ng physical, sexual violence, threat, emotional insults, and economic deprivation. Although not specifically named, Said the court, coercive control as a form of psychological abuse or harm has been recognized in RA 9262. Baka lumabas sa bar ito. That's the case of Tani de la Fuente versus de la Fuente. And it was penned by Justice Loden himself, decided on March 8, 2017. So take note of this. Okay. Is the crime of violence against women and children a public offense or a private one? Okay, it is a public offense, no? It's not a private. Sa private, alam natin, those who can file are only those enumerated under the law. But any citizen, for as long as he has the personal knowledge of the circumstances involving the crime, then the person may file. Okay, any person under the influence of alcohol, illicit drug, mind-altering substance shall not be a defense under this act. Well, there are protection orders, no, for the purpose of preventing further acts, and they are as follows: TPO, temporary protection order; BPO, barangay protection order; and PPO, permanent protection order. Child abuse law. Let's go to the child abuse law. The defined child abuse, okay, refers to maltreat. Pag 3B, ito yun. Maltreatment, whether habitual or not. No? It includes psychological, physical abuse or neglect, cruelty, sexual abuse, emotional maltreatment, or any deeds or words which debases, degrades, demeans the intrinsic worth and dignity of a child as a human being. Okay? Or unreasonable deprivation of his basic needs for survival, failure to give medical treatment, no? So it can be done only through once, pwede yun. It is inconsequential that sexual abuse occurred only once. So it includes physical abuse, whether the same is habitual or not. Elements of 5A, lahat dito relates to child prostitution. Accused engages and promotes, facilitates, induces child prostitution. Lahat yan, taking advantage of relationship to procure child as a child prostitute. Basta it refers basically to child prostitution. Now, 5B does not refer to child prostitution. Okay? What are the elements under 5B? No, accused commits an act of sexual intercourse or lascivious conduct. Second, the act is performed with a child exploited in prostitution or subject to other sexual abuse. Then the child is below 18 years of age. The law uses the term a child subject to sexual abuse. When is a child deemed subjected to other sexual abuse aside from child prostitution? Ito yun. When the child indulges, number one, in lascivious conduct under coercion or influence of any adult. No, under coercion or influence of any adult. Okay, in lascivious conduct under coercion or influence, there must be some form of compulsion equivalent to intimidation, which subdues the free exercise of the offended party's free will. So again, each incident of sexual intercourse and lascivious conduct with a child is a separate and distinct offense. So, yun. Halimbawa, 22 years old yung lalaki, 17 years old yung babae. Hindi malayo yung edad nila, no? Wala namang child prostitution, but he's charged of sexual abuse. And the man, sabi niya, it's consensual. It's consensual. So if that is the case, what must be proved? What must be proven by the prosecution? Kailangan yung element ng persuasion, inducement, enticement, or coercion must be present. If there's no persuasion or inducement, enticement, or coercion exerted against the minor child, then no liability under this one, under Section 5B. Can a person be charged of committing an act punished under Section 5B and rape at the same time? If the victim of sexual abuse is below 12 years of age, okay, filean mo siya ng statutory rape under Article 266 A1 and D of the RPC. On the other hand, if the victim is 12 years or older, the offender should be charged with either, isa lang doon, sexual abuse under Section 5B or rape. However, the offender cannot be accused of both crimes for the same. Hindi pa pwedeng pareho, isa lang pipiliin. Otherwise, double jeopardy will lie. Can rape instead be complex with violation of Section 5B? Rape complex with child abuse under Section 5B. You can easily answer this one because an RPC cannot be complex with a special penal law, right? That's a basic rule. Can an accused be convicted of acts of lasciviousness under RPC instead of violation of Section 5B of RA 7610? Yes, sabi ng court, the special circumstance that the child subjected to other sexual abuse is not an element in the crime of acts of lasciviousness, which is punished under the revised penal code. Yung bang rules of offsetting, mitigating, aggravating, applicable in 7610, it being a special law. I mentioned this a while ago, no? Since it's an SPL and yet it adopted the nomenclature of the RPC, the rules of offsetting applicable to 7610. Okay, we're now nearing the end. Safe Spaces Act, there's no actually jurisprudence on the matter. We'll just highlight topics which may be asked in the bar. Coverage of the Safe Spaces Act, gender-based sexual harassment committed in the following: street and public places. Second, online. Third, workplace. Fourth, educational and training institutions. So when you talk about public spaces, yun, streets, alleys, public parks, government offices, public utility vehicles, okay? And yung app-based transport network, kasama din nun. Gender refers to a set of socially ascribed characteristics, norms, roles, attitudes, values, expectations, identifying the social behavior of men and women and the relations between them. Pag sinabing gender identity and or expressions, ano ibig sabihin? It refers to personal sense of identity as characterized, among others, yung kanyang manner of clothing, inclination, behavior in relation to a masculine and feminine conventions. No? So a person may have a male or female identity with physiological characteristics of the opposite sex, in which case this person is considered as transgender. Okay. So these are the gender-based streets and public spaces sexual harassment. Ayun. Siguro medyo tatandaan nyo lang to, committed lang sa public space. Mga acts na to, catcalling, wolf whistling, unwanted invitations, persistent invited comments, relentless requests for sexual details, statement of sexual comments and suggestions, no? and other advances. Catcalling refers to unwanted remarks directed towards a person. Okay. Misogynistic remarks or slurs or any statements in whatever form or however delivered that are indicative of the feeling of hating women or the belief that men are inherently better than women. Sexist remarks or slurs or statements in whatever form or however delivered that are indicative of prejudice or stereotype or discrimination on the basis of sex, typically against women. Transphobic remarks or slurs are statements in whatever form or however delivered, indicative of fear, hatred, or aversion towards persons whose gender identity or expressions do not conform with their sex assigned at birth. Yun. Pag gender-based sexual harassment in public utility vehicles where the perpetrator is the driver shall also constitute a breach of contract of carriage. Okay. Ito na ang Section 11, punishable acts. No? Cursing, wolf whistling, catcalling, lahat na, no? Basta statement which invaded person's personal space or threatens the person's sense of personal liberty. Okay. Offensive body gestures, non-verbal, no? Or yung exposing private parts, no? 3, stalking, no? Tapos, acts na merong accompanied by touching, pinching, brushing against the body of the offended person. Any touching of any parts, including inner thighs, face, buttocks, or any part of the victim's body. No? Even, nakalagay doon, even when not accompanied with acts mentioned in 1 and 2. Kaya, ingat-ingat na lang din. Okay? Gender-based, meron ding online. Meron ding online sexual harassment. So, yan. Physical, psychological, emotional threats, unwanted sexual, misogynistic, transphobic, lahat ng phobic remarks. Yan. If you invade the victim's privacy through cyberstalking and incessant messaging, or uploading and sharing without the consent of the victim any form of media that contains their photos, their videos, sexual content. Yeah. Or unauthorized records or sharing of the victim's photos, videos, or other information online. Impersonating identities of victims online. Yun. Filing false abuse reports to online platforms. At ito ay imprescriptible. Offenses constituting gender-based online sexual harassment shall be imprescriptible. Yeah. So these are the offended parties sa BINORM. Merong special mention dyan. O kaya kung uniform PNP ka, no? Or any conduct of sexual nature and other conduct based on sex affecting the dignity of a person, unwelcome, unreasonable, and offensive to the recipient, whether done verbally, physically, or through text messaging, electronic mail. No? Yun. A conduct that is unwelcome. Kung unwelcome ka, huwag mo nang gawin. And pervasive and creates an intimidating, hostile, or humiliating environment for the recipient. This also happening applicable between peers, superior officer, teacher, trainee, to a trainer by a trainee. There's also gender-based sexual harassment in educational and training institutions. Ganun din yun. For only the venue is in the schools. Minor students are found to have committed acts of violence shall be held liable administratively. Yun. Data Privacy Act, process of personal, sorry, this is the last one. Information shall adhere to only take 10 minutes to principles of transparency, legitimate purpose, and proportionality. So let's go na lang sa ano. It has a territorial application. Ano? The act, practice, or processing relates to personal information about Philippine citizen. No? Medyo nawala siya. Data subject refers to an individual whose personal information is processed. No? So kailangan magkaroon ng consent. Otherwise, liable siya pagka information, personal information is given outside. Sensitive personal information refers to personal information, yung kanyang mga health, education, sexual life of a person, issued by government agencies, peculiar to individual, no? Lahat yan, no? They are protected. Privileged information also, no? Modes of committing the same, yung processing, yon, unauthorized processing, processing for unauthorized purposes, pagka-accessing, ito yung modes of committing, no? Accessing due to negligence, unauthorized access or intentional breach, pag-disclosure, unauthorized disclosure, or malicious disclosure, other modes, improper disposal, concealment of security breach, no, or combination or series of acts. Next, punishable acts. Baka may lumabas sa bar dito, just hang on. Unauthorized process of processing of personal information and sensitive personal information, no? Committed by persons who process personal information without the consent of the data subject, no? Or without being authorized under the Data Privacy Act. Next. Processing of personal information and sensitive personal information for unauthorized purposes committed by persons who process personal information for purposes not authorized by the data subject or authorized by the Data Privacy Act. Okay? Processing refers to any set of operations katulad ng collection, recording, organization, storage, updating, modification, retrieval, consultation, use, consolidation, blocking, erasures, or destruction of data. So yan. Pag unauthorized processing, no, at processing for unauthorized purposes, no, violation yan. No? Persons involved processing personal info or sensitive personal info. No? Committed on the left side by any person, on the right side, committed by an authorized person. No? The process is done for purposes not authorized by the data. Doon sa right side, process for unauthorized purposes. Doon sa left, unauthorized processing, the processing is done without the consent of the data subject, or the person has no authority under the law. Pero ding committed by a person who due to negligence provided access to personal information without being authorized under the data privacy or any existing law. Next. Unauthorized access or intentional breach committed by persons who knowingly and unlawfully or violating data confidentiality and security data systems break in any way into any system where personal and sensitive personal information is stored. Okay? Accessing due to negligence. And yan, and unauthorized access or intentional breach on the left side, on the right side. Pag sa accessing due to negligence, committed by providing access to personal information or sensitive personal information. He has no authority to provide access and there is negligence. On the right side, sa unauthorized access naman, committed naman siya by breaking into a system and such system stores personal and sensitive personal information. The act naman is intentional. Okay? And there is also malicious disclosure. Okay? And unauthorized disclosure. Okay? Yon. So merong malicious at unauthorized disclosure. Yung sa left side, malicious with malice or bad faith. The other one, without consent or data subject. Okay? And there's also improper disposal of personal information and sensitive personal information. Okay? And concealment of security breaches involving sensitive personal information after having knowledge of a security breach and fail to notify the National Privacy Commission. So, yun na yun. Okay? I think we have gone through a lot. I hope and pray that you will do well in criminal law, and I hope that you learn something out of my lecture. But you see, this is your dream. You fight for your dream. No, the Lord said that He's the Alpha and Omega. He's the Alpha. He's with you when He started this dream, when you were still in first year, when you finished your law, and He will not leave you. No, He's also the Omega. He will help you finish that dream. Don't deal on your disappointments, discouragements, no, the challenges of the past. Forget about those things. The Lord said that He is doing a new thing in your life. No, do you not perceive it? This is now the chance, no, of go. At eto na tatawid na kayo, no. All you have to do is to cross that, and a few months later you will become a lawyer. So make sure that you are in good health, and secondly, that you have a proper mental set. And of course, stay close to God, because you will stay closer to your dream. It's just ilang days na lang, no? Just pray continually, keep the faith, no? Sabi sa Bible, no, faith is the substance of the things that we hope for, the evidence of things not yet seen. How would you know that you will become a lawyer? We'll see it already through the eyes of faith. No? And then after that, sa oath-taking, that will be the manifestation already of your faith. No? And we are one with you. In Pulse, all the Danes, we are one with you. We're praying that all of you will pass the bar examination. And I know that you're all prepared. Ang kinakailangan lang, no, good health tayo. And of course, don't leave any blanks sa inyong pagsagot. And I'm sure you will do well. Keep the faith and God bless everyone, my future pañeros and compañeras.
Thank you very much, Dean Jim, for sharing with us your extensive knowledge on criminal law, and thank you for your words of encouragement and wisdom to our bar takers. We would like to present you with a certificate of appreciation. So if I may read it po. The Philippine Association of Law Schools, in collaboration with Rex Bookstore and Educampion, awards a certificate of appreciation to Dean Gemy Lito Festin for sharing his expertise as a research speaker on Bar Ops Pilipinas 2020-2021, the best bar ever webinar lecture series, given this 25th day of January in the year of our Lord 2022, signed by Mr. Don Timothy Buhain, CEO of Rex Bookstore. Again, thank you very much, Dean, and thank you to our partners, Rex Bookstore and Educampion, for making this event possible. We would like to mention that our event partner, Rex Bookstore, recently released a free digital copy of Bar Prep Ready Set Pass, a light read on useful tips for the bar exam. This material was prepared by lawyers for would-be lawyers, a product of collective wisdom and born out of shared genuine concern for the profession and the men and women who make it great. You may get your own copy through the link found on the past Facebook post. We would like to remind everybody that our frequently asked topics on the 8-bar subjects lecture series will resume tomorrow, Wednesday, January 26th. So make sure to follow the past Facebook page for the roster of speakers and for further updates. We hope that everybody tuned in to our stream, learned a lot from today's lecture from Dean Jim. Thank you, everybody. Have a great evening, and we will see you all tomorrow.